outside of a classroom. Your seats, please. Oh, to stand, please. Our dignitaries have arrived. Ladies and gentlemen, our distinguished guests have arrived. Could I request you all to please stand? Our distinguished guests have now arrived in the auditorium, and they will be joining us here on stage and in the audience very soon. So may I please request everyone in the audience to please take their seats so that we can get started as soon as they are here. Ladies and gentlemen, do take your seats because our distinguished guests are about to join us from the back of the stage to the front of the audience. So may I please request you all to take your seats. Ladies and gentlemen, our most distinguished guests have now arrived at the TP Ganesan Auditorium, the venue of Lexposium 2025, a day of insight, dialogue and inspiration and a vision for the future of justice and legal education in India. Ladies and gentlemen, may I please now request you to rise for the Tamil Thai Vadathu being performed by students of the SRM University.
Check, check. Check. நீராரும் கடலுடுத்த நிலம் நீராரும் கடலுடுத்த நிலமடந்து கெழிலொழுகும் சீராரும் வதனமென திகழ் பரத கண்டமிது தெக்கணமும் அதில் சிறந்த திராவிடனல் திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிலமை திறம் வியந்து செயல் மறந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே.
As the ancient light dispels darkness, so does knowledge dispel ignorance. As is tradition in Indian academia, we begin today's proceedings by invoking the light of knowledge and wisdom. We now move to the ceremonial lighting of the lamp, a symbol of purity, clarity, and enlightenment, as we set the stage for a day of rich legal discourse and learning. For the lighting of the lamp, I would like to invite on stage Dr. T.R. Parivender, Founder and Chancellor, SRM-IST, Dr. P. Satyanarayanan, Pro-Chancellor Academics, SRM-IST, Honorable former Chief Justice N.V. Ramanna, Dr. Abhishek Manu Singhvi, Dr. Nitin Nagarkar, Pro-Vice Chancellor, MHS SRM-IST, Professor SRM School of Law, SRM-IST, and Dr. S. Ponusami, Registrar. Thank you to our esteemed guests. We are now honored to felicitate our distinguished dignitaries whose presence today is not only inspiring for future lawyers and judges of this nation, but also reflects their own commitment to the growth of the legal profession and to nurturing India's young legal minds, many of whom are seated in the audience before us today. May I request that the guests be presented tokens of our respect and gratitude. Okay. Before we move on to the felicitation, I would like to welcome all of you once again, ladies and gentlemen, to Lexposium 2025, a cradle for future jurists. This prestigious event is being graced by legal luminaries, former chief justices, Supreme Court judges, eminent advocates, and thought leaders, all gathered with a common mission to shape the future of law in India and to empower the next generation of legal professionals. To open this landmark conclave, we now invite a visionary educator and the driving force behind the SRM group of institutions. Please welcome Dr. T.R. Parivender, Chancellor of the SRM Institute of Science and Technology, for the opening address.
SRM School of Law, along with NDTV, has arranged a wonderful program, Lexposium 25, the Cradle for future jurists. Perspective and deliberations on justice for diverse and equitable India. Honorable Chief Guests, former Chief Justice of India, N.V. Ramanaji, and the very popular and famous, particularly who need support for their cases, always looking for to take an appointment, Honorable Abhishek Man Singhviji, Dean, Directors, Registrar, and dear participants. SRM is a well-known university in India, and it is successfully managing and running courses like medical, engineering, dental, arts and science, so on. All our ventures with all these subjects and faculty, we are very successfully, parents and students of this country always give preference to take admission in this university. Though it's a 40 years old university, regarding School of Law, 11 years old, the law school was started, and Maryland of US Supreme Court Chief Justice at the time, she graced and opened this law college. The academic concerned, SRM University is never second to anybody in the country. Therefore, I do not think just like law education is along with the other one. You are the really need of this country. Advocates are real advocates, capable advocates are very much needed in this country. Let's not think that only engineering and medicine alone will give you future, not so. Therefore, it's even better than medicine and engineering. Once you are well qualified, you are seriously attended to your course, I am sure there's no retirement for your work on your life. What is needed is a senior, honest, serious, very honest advocates are public are looking for. Actually, the country is being ruled by Constitution. The Constitution, you all know, there are 4 pillars for the Constitution. One is executive, legislative, judiciary, and press and media. These are all called as 4 pillars of this country. In this, legislature should be given much importance because at this condition, a country which is not well matured by democracy, at any point of time, any difference of opinion occurs, where it may be from the individual and to the government, or among individuals or 2 people of the country. They resorted to only to advocates and courts. In this country, several level of people are there. Poor, rich, underprivileged, all kinds of people are there. Law profession, in fact, a noble profession if you are honest in your profession. Therefore, students of this university or from students from other colleges and any practitioners are here, I welcome you to this Lexposium, and you are very much needed for this country. But remember how successful you are, not by the college you study or the professors they taught to you. More and above, your seriousness and honesty in your education. You may be in any college or any university. The 4 years of time or 5 years of time you spend should give you not only a future for you, life for you, it really helps the poor people and good business people. At times, though they do right, they don't get on a judgment, proper judgment. I myself faced many judgments. However, it's not a place to disclose and talk about. But remember, SRM concerned, whether it is engineering, non-engineering, we give our best infrastructure. One of our chief guest today said, I heard about, but never expect such a beautiful infrastructure. Manu Singh ji said. So this university concerned, we never compromise infrastructure, quality, and also discipline. Once you come into the campus, your parent or your father, whoever it is, they need not worry about. That is why we are able to be very successful in managing this university. Not only that, this university has got 4 campuses throughout the country, and 60 country students are studying here. In those days, when they want to do law, in those days they will go to the London and foreign countries like that. That necessity is no more here required. Therefore, now in front of you, very successful, ever sat in the Supreme Court, 2 seniors are there. Seeing them itself on the stage, it's a great motivation for you. At this moment itself, you must think, yes, I may complete my legal study. I will go to High Courts, Supreme Court. When the retired Chief Justice of the country came and spoke to me. I enjoyed this. I got the very valuable points when he was speaking here. It's a great motivation. Likewise, the senior people who are there on the stage, you had the opportunity to see them get by the speech, you will be motivated. So, I am sure having come to this seminar, symposium, Lexposium, I am sure you will go with a lot of information, ideas, if you are practicing in the court or High Court or in Supreme Court. I want you to enjoy the sessions fully, and any doubts, there are 3 to 4 sessions are there. People who are on the stage at that time will be loving to listen to you and answer your questions. I wish you all the best.
Thank you so much, sir. May I please now request you to felicitate our distinguished guests on the stage with us. We now invite Dr. P. Satyanarayanan, Pro-Chancellor Academics of SRM IST, to deliver a special address to set the tone for today's powerful conversations.
A very good morning to you all. Honorable former Chief Justice of India, N.V. Ramana, esteemed judges of the Supreme Court, Chancellor of SRM University, our respected Senior Advocate of Supreme Court of India, Dr. Abhishek Hanusingvi, members of the bar and bench, distinguished scholars, leaders from the legal fraternity, dear faculty colleagues, and most importantly, our students. It is with great pride and a deep sense of gratitude that I welcome you all to Lexposium, a celebration of legal thought, and more importantly, a reaffirmation of our commitment to justice, truth, and transformation. The presence of so many judicial legends and legal minds in this gathering is not just an honor, It is a reminder of the immense responsibility that legal education carries in shaping the future of justice in our country. It is a true privilege to welcome the Honorable former Chief Justice of India, under whose tenure the highest values of the Constitution were upheld with dignity and depth. Your presence today is both a blessing and an inspiration to every aspiring legal minds in this hall. Former Chief Minister of Tamil Nadu, Dr. C.N. Annadurai once told, சட்டம் ஒரு இருட்டறை, அதில் வழக்கறிஞர்களின் வாதம் ஒரு விளக்கு, which means the law is like a dark room and the lawyer's argument is a lamp within it. This profound imagery reminds us that law by itself can be opaque and daunting. It is through argument, interpretation, and clarity that we bring light to it and make justice accessible. A law school must be more than an academic institution. It must be a crucible for conscience, a space where the law is not only learned but lived. It must equip students not only with the language of law but with the moral clarity to question power, the humility to listen, and the courage to speak for those who cannot. At SRM, we do not see legal education as a lifeless study of rules and procedures. We see it as participation in a larger unfolding where each student became a change enabler, not in isolation, but within the greater web of society, history, and the evolving systems. One of the main reasons India's democracy has remained intact over the decades is because of the resilience and integrity of its judiciary. In times of social unrest, institutional breakdown, or political crisis, it is the judiciary that the people turn to. As is often the case, it is the judiciary that restores the faith and balance. Among all the public institutions, the judiciary continues to command the highest respect and trust from the citizens across the country. As educators of future legal professionals, we carry the responsibility to nurture individuals who will uphold this remarkable pedigree of integrity, trust, and constitutional duty. At SRM School of Law, we have chosen our guiding words carefully. Our tagline is "In Pursuit of Truth," not because we claim to possess the truth, but because we recognize that truth, like justice, is not always obvious or easily agreed upon. It must be sought, questioned, and sometimes even fought for. In law, we often aim for justice, but justice is shaped by process, precedent, and perspective. Truth, on the other hand, is often elusive, complex, and uncomfortable. But without truth, justice cannot stand. We believe that the legal education must teach the students not just how to argue, but how to seek, not just how to win, but how to understand. And so we are not in pursuit of victory or certainty, we are always in pursuit of truth. As we unveil this new building, let us remember, walls don't build institutions, people do. And more than people, it is their willingness to learn, to struggle, to evolve, and to work for others that gives a meaning to the institution. This very building draws its architectural inspiration from the Supreme Court of India, a symbolic gesture of our deep reverence for the institution of justice and a visual reminder of our students that they learn under the same values that uphold our democracy. We dedicate this space not just to academic excellence, but to the idea of justice as a dynamic, evolving, and deeply human quest. To the honorable judges and senior advocates here, your lives reminds us that law at its finest is an act of service of truth, not convenience, not popularity, not power. To the students who are here, you are not just learning the law, you are learning how to be a part of something greater than yourself. May you rise on not just to interpret the law, but to embody its spirit. To our faculty members here, may we continue to educate not just sharp minds, but wise souls. Let us now open the floor to those whose judgments shape our laws and whose lives illuminate them. Thank you very much.
It is now my privilege to welcome a towering figure in Indian jurisprudence, a former Chief Justice of India whose tenure is known for his deep commitment to constitutional values and access to justice. Please join me in welcoming Honorable Chief Justice of India, retired N.V. Ramana, to deliver the first keynote address of the day.
Vanakkam, good morning. Professor Dr. T.R. Parvendran, founder of this great institute, Dr. P. Satyanarayana, Pro Vice Chancellor, Dr. Abhishek Manu Singhvi, I need not introduce all of you. He's a great scholar, parliamentarian, jurist, and senior advocate, and several times member of the parliament. Professor, Vice Chancellor of Medical Institute, Nitish Naikar, Professor C.F.M.L. Vinay Kumar, Registrar Dr. Ponuswamy, Srimati Sudha, Dean of the Legal Faculty, Mr. Pradeep Rai, Senior Advocate from Supreme Court, other advocates, students, teaching staff, and my dear law students. Institutes such as SRM have brought a world-class education closer to home. They have ensured that talented young people do not have to migrate far. By imparting value-based education, discipline, they have contributed to regional growth, leadership, and strengthen the economies. Today, the Chancellor has inaugurated, on behalf of the Law Minister, the new building, and I am very happy that he inaugurated and created good infrastructure. May this new facility continue to shape future generations who will uphold the rule of law and strengthen the democracy. I'm also happy inaugurating the statue of Father of the Nation, Mahatma Gandhi. At the outset, I need to state that 15 minutes time is allocated to me. And I will assure you, within the time limit, I will complete my speech. On lighter way, we have Dr. Singhvi here, and I don't want to take too much of his valuable time. He's a very senior lawyer. Most of you gathered here are law students. I congratulate all of you for choosing law. I wish that all of you join the practice. Although it is one of the most challenging professions, yet it is very exciting. There are already many esteemed guests lined up today to enlighten you about law. However, I will speak about the practice of law. The practice of law is not like any other job or profession. For instance, when a patient goes to the doctor gives him a medicine or prescription, something, and perhaps that is the end of his job. If you approach an engineer with a problem, he will give some design or solution. But however this legal profession is concerned, legal remedy is not in the hands of a lawyer. Because if you go with a problem to the lawyer, even he has wonderful ideas or knowledge to deal with the problem, ultimately one has to go through a system of procedure and initiations. To capture the essence of the legal practice, let me tell you a story which was written by a famous criminal lawyer in Telugu, Rachakonda Viswanatha, in the year of 1960. But every bit of it is still relevant. Of course, it is in Telugu language, but I have translated and I am going to read the translation. Murthy, after getting a law degree, wants to start his career. He approached a senior lawyer with humility. The senior lawyer told Murthy to remember one important thing. He stressed that to succeed in this world, you have to do the following things. The early bird catches the worm, said the Englishman. Englishmen are very wise. He never does anything unless there is something in it for him. That is why he should reach the court every day early and get the gates open. And in the evening, wait until the court gates are closed. Always be alert and make sure that you are present in the court each and every day. Just like the cranes stand on the shores and foxes hang around the grayards. Of course, this kind of comparison is not very pleasant, but this is what we must do. If you want to shine, you must always be in the court. You know that the court is like a dense forest. Hyenas mimic human laughter in the forest. If you go closer thinking there is another human, the hyena will eat you. We lawyers need to attract the clients that come to the court in this manner. Don't be shocked. It is the fault of the person who enters the forest, not ours. But there are bigger animals than hyenas. If we are not careful, then those animals will eat us. These courts, law books were invented by the British. There are many courts to approach. There are many judgments of judges to pick and announce whatever ruling he wants. There are many rascals available to testify. We are there to justify. Whether it is a civil case or a criminal case, it is all about evidence, not about any truth. It is enough to just shout words like justice, truth, righteousness. Know that everything is illusion, maya. How can any sin touch us when the system is like that? All these sins go to the judges. All the expenses are borne by the parties and all the fees are ours. English people owe their existence to the courts. They are big trickers, sir. They came to our country and sold our salt to us and said, you ate our salt and be loyal to us. They built courts and jails for us and built bungalows for themselves. After hearing this, Murthy became nervous and senior told him, don't be nervous. I spoke cynically, but this is the truth. If you remove the shred, the reality is this. Don't panic or be afraid of. This is how this famous Telugu writer and senior criminal lawyer who dedicated his life to serve the poor people in a humorous way explained the legal profession. Now, come back to our profession. A lawyer does not operate within insulated walls. His craft depends on controlling so many factors around him. A young lawyer walks on a tightrope every day. He is to understand the judge's mind, handle lawyers, manage clerks and clients. If you are a first-generation lawyer, these difficulties increase manifold. From my experience, I can say obtaining law degree is easy. However, it is extremely challenging to earn livelihood and face the challenges, and surviving in the profession is very big issue. So, we have to keep these things in mind. Why are you studying law? Sometimes these are the questions we faced during our times, not now. Because according to the people at that time, law is the last resort and last course which people used to take. The first question they used to ask is, why are you studying law? Did you not get any employment? Or you not getting any marriage proposals? This is how they used to question when we joined in the law those days. Of course, those days has gone. All jovial laughs aside, as young aspiring lawyers, apart from knowing law, you must understand the legal system and its interdependence with the other institutions. Let us begin by understanding India's progress and paradox. India's growth story is filled with resilience and revival. We have sent successful missions to space. We are leaders in digital transformation. Our economic growth is admired across the world. Yet, alongside this remarkable progress, we still have persistent challenges of poverty, malnutrition, unemployment, etc. While the journey so far is laudable, there are many who is still waiting to receive their benefit of growth. The above picture of India often reminds me about the words of Charles Dickens, who has explained in his novel, Tale of Two Cities. He portrays despair and hope. This is the duality of India. Growth without equality is incomplete, and development without justice is fragile. In this background, as the members of legal fraternity or law students, where do we stand? What role can the legal system play in bridging this gap between aspiration and reality? The answer lies in reaffirming the true purpose of law. Why do we need law? We need law because it regulates human behavior. It is an instrument of social change. Where there is law, there is order. Where there is no law, there is anarchy. As Aristotle once said, man when perfected, is the best of animals. But when separated from law and justice, he is the worst of all. Unquote. Statutes or laws will remain as mere words on paper unless there exists a system to give them life. The Indian legal system began as a colonial inheritance. However, post-independence, Indian courts have emerged as central pillars of constitutional governance. Now, what are the challenges before the courts? Now, I will tell a small saying in all languages, almost Indian languages, a popular saying. It says that while a litigant who loses the case cries in the court, the winner cries after going back to his home. So, it may be humorous, but these words reflects a painful truth which points out towards a deeper crisis, that is, people's faith in the institution. The strength of the judiciary lies in the trust of people. Without the trust, even the most reasoned judgments become meaningless. There are several factors which are leading to the erosion of the public trust. These are pendency of cases, high costs of litigation, procedural complexities. All these ultimately affect justice delivery. When people lose trust in courts, they start looking elsewhere. Justice for justice. This lends to unrest, violence, and breakdown. The trust is one of the most important component where we have to repose and try to protect the image of the institution. It is not new to the judicial institutions to face the issues of credibility from time to time. Of late, the criticism has been severe, perhaps one of the strongest challenges. This is where the judicial leadership will rise to the occasion. Now, the next question is, who has to render justice? Delivering justice is not the burden of one institution. It is the responsibility of all constitutional stakeholders. Even our Constitution under Article 38, 39A places an obligation on the state to render justice. The blame of delay cannot be attributed to judges and lawyers alone. In this light, let us see how the other constitutional bodies have to perform their duty to ensure the functioning of the legal system. Many people think that laws are made by the courts. We have to dispel this notion. The legislature who makes laws. Unfortunately, rushed legislation without adequate foresight clogs the judicial system. Poorly drafted laws inevitably multiply litigation. Refinement of proposed laws requires consultation with all stakeholders and meaningful parliamentary debate. Unfortunately, this exercise has declined in recent years. We need to assess the ground reality and practical impact of constitutional amendments and legislative enactments. Now, after decades of their implementation, we need scholars and experts to analyze which of those amendments have truly brought positive changes in the lives of the citizens. I hope this university takes up some projects on this subject. We need to ascertain whether the changes were merely cosmetic or have they served their purpose, or do they need further changes. It is the duty of the government to strengthen the judicial infrastructure and create courts to meet the growth and needs of the people. I want to bring all of your notice. As the Chief Justice, I tried my level best to create an infrastructure corporation across country to take care of the infrastructure of the judiciary. Unfortunately, government has not cooperated. That's a different story. Now I want to show you a public notice issued by this National Company Law Tribunal in Delhi. It is in the capital city of Delhi. We all think that now this most important judicial, more than Supreme Court, High Court, it is the company law tribunals which are attracting the public and which are discussed too much. They issued a notice on 3rd September saying that we are closing the courtrooms because we don't have infrastructure. The building is leaking and may cause serious deterioration of the false ceiling, creation of imminent risk of collapse, short circuiting of electrical fitting, and consequently fire hazard. The situation poses a grave risk of the safety of the honorable members, officers, registry, land advocates, litigants, all other persons. This is the stage of the tribunal, National Company Tribunal in Delhi itself. Imagine the stage of the construction or the infrastructure across the country about the other courts. So that is the reason why we, as members of the legal professions, particularly lawyers, must have take up these issues. Judicial efficiency greatly depends upon the timely filing of the judicial vacancies, appointment of the public prosecutors, etc. We live in today an age of over-governance. Excessive and poorly designed rules create more disputes. The overload caused by a regulatory culture adds to burden of pendency. It is expected that the executive follows the principles of natural justice before taking any action. Otherwise, people has no option except going to the courts. Moreover, the authority of the courts depends upon the implementation of their orders and judgments. But unfortunately, majority of the judgment, until unless you file a contempt, they are not going to implement. Now coming back to the criminal justice delivery system, the administration of criminal justice is a big punishment because the process has become a big punishment. By the end of the day, you may get acquittal, but many days you have to be in jail without getting a bail. So this has become a big punishment. Fundamental reforms must begin with public prosecutors. They must act independently. They must be answerable to the courts, not to the bosses who they appointed. The investigating agencies must equip with latest technology and must be answerable to the courts. Police must be accountable, and faulty and delayed investigations lead to wrongful confinement, incarcerations of innocent citizens. These things has to be corrected. Now, what can lawyers do to address these issues? During the freedom struggle, we have seen Mahatma Gandhi, Jawaharlal Nehru, Dr. Ambedkar, Tanguturi Prakasam, Rajagopalachari, Sardar Patel, who mobilized the entire nation and people against the British, against the colonial injustice. They were lawyers. Many sacrificed their liberty and properties to pursue this independence movement. Post-independence, lawyers played an equally crucial role in drafting the Constitution and shaping legislative bodies. Their legacy highlights the noble responsibilities of the legal profession. But presently, we are witnessing the declining trend of lawyers in public life. Today, how many lawyers are taking up the role of legislators? An electoral contest grow, resource intensive. Fewer lawyers entered legislative life. the legal profession itself become more specialized, commercialized, and inward-looking. Lawyers have been accused of profiting out of misfortunes. In a lighter way, in an English saying captured this, I quote, "For fees to any form, they mold a cause. The worst has merits and the best has flaws. 5 pennies make a criminal today, 10 pennies tomorrow wipe the stain away," unquote. A lawyer's duty extends beyond academic interests. The integrity of advocacy is as important as the wisdom of the bench. The independence of the profession must be safeguarded against intimidation and interference. The collective voice of Lawyers Association should champion the rule of law. And very recently, we all witnessed such exemplary actions. Another issue which now we are facing about the gender diversity and inclusivity. The issue of diversity and inclusivity on the bench is a very serious problem. In 75 years of the Supreme Court, only 11 women have been elevated so far. The last time women judges were appointed the Supreme Court was in August 2021, when 3 distinguished women joined together. Now there is only 1 lady judge in the Supreme Court. Our institutions must reflect our social fabric. Gender diversity and inclusivity is not tokenism. It is the necessity to enrich our perspectives with social realities. This issue needs larger consideration. Inclusivity does not happen naturally. Judiciary also not immune to this. Bringing inclusivity calls for concerted efforts at the highest level. Now, and what is the message I want to tell to the young students is, legal education does not end in classrooms. There is a great disconnect with the grassroots realities of our society. Books will teach you the letter of the law, but society will teach you its spirit. As young lawyers, you must expose yourself to varying experiences of legal practice in trial courts, tribunals, different institutions and forums. There are another dimension we often overlook: the cultivation of scientific temperament and critical thinking in society. The spirit of inquiry must guide every stage of you. It is the essence of advocacy. Being equipped with the knowledge, we have the responsibility of promoting constitutional culture and simplifying its principles for the public. Sadly, even today, many citizens do not know their constitutional rights. In fact, even lawmakers and lawyers sometimes fail to grasp its spirit. We have a great constitution. However, the constitutional scheme is not effectively working. We must work towards the proper implementation and realize its goals and aspirations. It should be our constant endeavor to bridge the gap between the Constitution and the people. As future national builders, carry forward the spirit of the Constitution in every step in your career. Be fearless and upright. I will end my speech with Rabindranath Tagore, where the mind is without fear and the head is held high, where knowledge is free, into the heaven of freedom. My Father, let my country awake. Thank you very much for giving this opportunity. Thank you.
A warm round of applause once again for Honorable Chief Justice Retired N.V. Ramanna, who is leaving a very thought-provoking question for the students gathered here today. Why are you studying law? Thank you, sir, so much for your words. on getting a law degree versus actually practicing law. And thank you also to all our dignitaries on the stage. May I please request you all to now take your seats in the audience while we set the stage for our next sessions. Thank you to the dignitaries. Right, ladies and gentlemen, from the courtroom to the parliament, our next keynote speaker bridges the worlds of law, policy and public discourse. A fourth-term MP and former chair parliamentary committees on law, home, commerce, member of the CWC and senior advocate of the Supreme Court, he brings an insider's view of the legal system's strengths and its need for reform like nobody else. We are now honored to welcome on stage Dr. Abhishek Manu Singhvi for his keynote address on judicial reforms and systemic changes for faster, fairer justice delivery. Beg your pardon. A round of applause, please, for Dr. Abhishek Manu Singhvi.
Honorable former Chief Justice of India, whom I just said looks pretty much the same as when he left us from the Supreme Court. seems to be no change. A man who conducted himself with least ostentatious and maximum results, and the only Chief Justice of India who appointed on the same day 3 lady judges to the Supreme Court. The Chancellor of this remarkable institution, we had heard of it up north, but seeing the physical scale and size of SRM amazes and never ceases to amaze. And this is only one campus, 5 of these campuses. Truly a visionary, truly a leader who has developed these set of institutions. Esteemed members of the academic community, from the Pro-Chancellor downwards, above all, students who are here at this Center of Learning. Friends, to even try and do partial justice to the topic of reforms in the administration of justice to reduce delays in 25-30 minutes should earn me a Nobel Prize for miniaturization. I will therefore do the job of a fan dancer, touching upon various facets of the subject without really covering it. So let me straight away plunge into it. You know, the field of administration of justice is a field full of paradoxes. In India, we have the highest and the fanciest flights of jurisprudence, the most sophisticated, nuanced doctrines. In the bench and in the bar, the best and the brightest in the world. A vibrant, pulsating democracy, a dynamic legal system, avant-garde doctrines like PIL, like basic structure, judicial review of a scale and magnitude which would make the judges of Marbury and Madison blush. No other place on planet Earth has judicial review of the kind we have here. And yet, the paradox, the sad paradox is that we must hang our head in shame when we turn to the scourge of arrears, backlog, the battle of the bulge, the theme of this address. We have been sermonizing, lecturing, seminaring, talking for the last many decades on this scourge of arrears, pendency, delay, etc. And yet, under our very nose, from the 2018 figure of 3.5 crores, which if you tell any foreigner is shocking enough, from the 2018 figure of 3.3 crores, we are now, and this is a figure 2 years old, July 23, a parliamentary stated figure, of 5.02 crores. Under our very noses, we have climbed the wrong hill and achieved the wrong milestone. How long will we blame COVID? How long will we keep on appointing committees, commissions? My favorite quote about these bodies is what a wag once commented, which I love to repeat. A committee is the group of the unfit, appointed by the unwilling to do the unnecessary. So you can keep on appointing them and getting their reports till the cows come home, but under your noses, the arrears have ballooned from 3.3 crores to 5.02 crores. But when you go into the details, which I'm going to try and do in my 25-30 minutes, you realize Benjamin Franklin's apt phrase, "For want of a horseshoe nail, a kingdom was lost." Many of the panaceas and remedies are very small, practical, nitty-gritty. But unfortunately, we have not applied them consistently. I have been advocating, more particularly, I think, vocally and aggressively after Chief Justice Ramanna left the court for a common minimum program between successor Chief Justices, a CMP-like political parties. Chief Justices each wants to leave his stamp. So you must first agree to disagree on many issues. But at least on 5, 7, 10 issues, you and the next and the next and the next and the next, all the Chief Justices up to 2032 or 2034 should have a CMP, a common minimum program. Decide those core 5, it doesn't matter what they are, 5, 6, 7 for the benefit of the court, and then uninterruptedly, without zigzag mid-course corrections, follow it. Too often in this country, we change, we modify, we dilute, we do zigzagging, and therefore the efficacious final result of these policies do not translate on the ground. So friends, as I plunge into the details and give you my 10, 12, 15 wish list of changes, let me start with a few preliminary points, completely general and preliminary, but important to keep in mind. First, till recently, and I've been speaking on this subject for over 2 to 3 decades, till recently, reforms in the administration of justice, which includes this whole gamut of delay, backlog, etc., was not a taught subject in law programs across the country. It's quite an amazing thing. You would be taught contract law and constitutional law and tort law and this and that, but you were not taught what they don't teach you at Harvard Law School, how to run the legal system. The nitty-gritty of reforms in the administration of justice. I'm told happily it is now changing, but still slowly. Second, we need far fewer sermons, far fewer lectures, including this one, and much more implementation on the ground. Consistent, continuous, uninterrupted, unchanging implementation. And you'll start seeing the changes. Third, this figure of 5 crores, if you go and attack it properly, to a large extent you will find it's a house of cards. It can be made to collapse with not much difficulty. Fourth, follow Thomas Hardy's dictum, take care of the small things, the big things will take care of themselves. Frequently, we do the reverse. Fifth, have a holistic plan, including the CMP. The holistic plan must be both prophylactic, preventive, as also ex post facto curative. And it must be tied into one holistic plan, not piecemeal, not episodic. And finally, bring in attitudinal change. Attitudinal change has happened in the Supreme Court from the 1990s, where I was personally, as a much younger lawyer, associated with the so-called Ahmadi project. And the Supreme Court remains an island of excellence and exception. It is the many Indias in one syndrome. So the Supreme Court is not a good example when we talk of arrears. But you've had attitudinal change right early on in the 90s, which is why they've managed their arrears much better than the other 2 layers of the Indian judiciary, the high courts and the district judiciary. Well, friends, first, the answers are obvious. They don't require rocket science. They don't require too much of thought. You can't have lovely, fantastic buildings, equipment for hospitals, medical equipment, but no doctors. How are you going to treat patients? You have the same thing in all the grand court buildings will amount to nothing when, just a simple statistic, at no point of time after independence, that is 78, 79 years ago, at no point of time have more than 2/3 of the entire High Court judiciary of 1100 odd been filled. So at any point of time, 1/3 is vacant. 300 odd, 330, sometimes more. I'm giving an average. At no time has more than 3/4 of the lower judiciary, the district judiciary, been filled. That's roughly 25,000 odd. 1/4 is always vacant. How can you talk of arrears? If your sanctioned strength is not filled, all these sermons are empty unless you fill them. How you fill them is your problem, but you have to fill them. Second, if you closely analyze these arrears, More than 5 years old are only 25% cases. This is another surprise. Out of 5 crore odd cases, more than 5 years pendency is only 25, 1/4. You must straight away in every court across the country, each district court, each civil court, each high court. Supreme Court doesn't really need it that much. Start a second track. One track which deals with filings and disposal, the traditional track, but a separate track of judges which ensures dealing with these above 5-year 25% cases. They will vanish in a few years. Many of them are infructuous. Many of them are just numbers on a piece of paper. Nobody has tracked them. And imagine when you get up in the morning and you read that there's a 40-year-old case in X High Court, there's a 35-year-old case these are stray cases in Calcutta High Court. If you attack these 25% out of the 5 crores, more than 5 years old, you can pretty much get rid of them on a second separate track which only deals with them. Something as simple as I said, everything I say will be mostly utter, banal common sense. Occasionally you might think it is uncommon nonsense, but usually it is only common sense which is required. Let's turn now to the further ABCD, the access for A, backlog for B, C for costs, and D for delay. The ABCD of this system. This issue of vacancies, 33% in the High Court, 25% in the lower judiciary. You know, a chap called a professor in London School of Economics called J.A.G. Griffiths wrote a delightful penguin book in 1960s called The Politics of the Judiciary. When he wrote that book, there was a huge uproar in a conservative country like England. How the hell can you use a phrase called politics of the judiciary? Our appointment process today would make the 1960s Englishman and J.G. Griffiths blush. Why do we have this 1/3 at the High Court level? If you blindfold any student here who's not a lawyer and send him to all the 28 High Courts across the country, he can tell you in 1 month who are the best 5 or best 10 to be appointed. So selection of the best 5 or 10 is not difficult even by a blindfolded non-lawyer. The problem in our system is that after we know who they are, instead of appointing them, we start disappointing them. That's the problem. And that process of disappointment takes ages. Now we have the figures. Some 33% things may be recommended by the collegium, and I'm not talking politics, I'm not talking government A or government B. But 40% may be pending. Now you made the law. Why don't you implement it? You made the law which says very clearly, 7 judges, 9 judges, a second referral binds the government. Now the percentage of cases pending, re-referred and not appointed after a second reference is still very high. I have publicly, and I repeat it here, many years ago, and I have no hesitation in repeating it, on a second referral, if your appointments are delayed, why have you not issued a single notice of contempt of court? Not to very highest, but maybe to the law secretary. The delay will stop immediately if you do it in 2 cases. But you need to be bold and unconventional to get rid of these. This has gone through a process of first collegium, second collegium, reference back, and a second reference. There's no reason for a second delay. It's just that you don't use the powers which you have yourself written. And this is, by the way, remember, when we have agonizingly climbed from 11 judges per million of Indian population, lowest in the world, to 19% because of Supreme Court stick. But that 19 or 20% is the sanction strength. If 1/3 is vacant, you are actually functioning at 15 or 16 judges per million of Indian population. The figure in US is 50 million per population. The minimum average required for India is 33 judges per million of population. We are not able to fill our 19 judges per million of population. And the funny part is that many years ago, we increased the sanction strength of each High Court by 10%, 20%, 25%. No High Court has even fulfilled its pre-increased sanction strength. So you increase the strength, but you are functioning below the pre-increased sanction strength. Now, friends, as I've already said, you must have a second track to deal with cases more than 5 years old, and you must have fuller complement of judges to deal with the main track of 75%, which are less than 5 years. Fifth, the Supreme Court did me the honor of quoting my article in one of the judgments of the Supreme Court called Lok Prahari. Many years ago, I had written a piece. And I said it's incredible that there is an article in the Constitution of India called 128 for the Supreme Court, and another article inserted in 1963, a parallel one for the High Courts, called 224A for ad hoc judges. Ad hoc judges can be appointed to High Court X once they've retired from X or retired from any other High Court other than X. Do you know that to the best of my knowledge, not a single High Court ad hoc appointment has been made? The appointments to the Supreme Court have had 3, 4 or 5 in 75 years, ad hoc judges. That too not for the last 20 years. Now the reason I say this is that you fight, you do politics, you disappoint instead of appointing, you delay. That is the time when you can use a category of tried and tested pool of people who have retired. There are a large number of anonymous, hard-working, decent judges whom you don't need to test again because they pass through the system. They are retired. Why don't you appoint those as ad hoc till you fight over your appointments and not have 1/3 of High Court vacant? Sixth, Swaminathan Iyer, a very renowned economist, did some statistical survey and wrote some 4 or 5 years ago. I don't quite accept his figures. I think he's too optimistic. But he, on the lower side, said that only 2,200 judges in lower courts would virtually clear all the, 2,200 additional judges in the lower courts would virtually clear the arrears. And 100 to 150 additional in the High Court. Supreme Court, anyway, I don't think is a real problem. Why can't we do this? This is not anything great. We talk about going to the moon, we talk about space, we talk about deep sea underwater diving. This is not a big thing. That's why I said, for want of a horseshoe nail, a kingdom was lost. Take care of the small things, the big things will take care of themselves. Then, it is not a question, it's also a question of assessing the speed. You must remember, the power of technology is the power of information sharing. The power of information sharing is the power of awareness. And the power of awareness is the power of embarrassment also. Why does the High Court, every High Court and indeed every district court, every month, not publish a performance assessment report of each judge? You are not trying to deliberately embarrass a person. A magistrate, a senior magistrate in the 1960s in Delhi did that. And the entire approach changes by the fact that people realize that they are being assessed and their figures are published in terms of dealing with cases. You can do it without comment, but use the power of information to do performance assessment and publish the figures. It carries with it an inbuilt power of embarrassment and therefore of greater achievement if you are sensitive to criticism. Of course, it goes without saying as my 8th point, it's not about numbers alone. It's very much about quality. It's no point appointing a horse in the place of a goat or a goat in the place of a horse for that matter. And one bad appointment people don't realize is something you suffer for at least 10 to 15 years and it spawns a progeny of hundreds of cases wrongly decided. All this ABCD, access, backlog, cost and delay, was very well put by Palkiwala more than 30 years ago, who said then, I just quote him, "May I turn now to the situation in India, which has the second largest number of lawyers in the world. After US, we still have the second largest. While it is true that justice should be blind, in our country it is also lame. It barely manages to hobble along. The law may or may not be an ass, but in India it is certainly a snail. It moves at a pace which would be regarded as unduly slow in a community of snails. A lawsuit once started in India is the nearest thing to eternal life ever seen on this earth. Some have said that litigation in India is a form of fairly harmless entertainment. But if so, it seems to be a very expensive way of keeping the citizenry amused. That is sarcastic, that is caustic, that is scathing, but it is completely true. Let's look at, as a ninth point, ADR. Actually, ADR is broadly four things: arbitration, mediation and conciliation I treat as one, Lok Adalat, a little bit of sprinkling of Gram Nyayalayas. Arbitration, unfortunately, has largely failed because it has become very aptly called pre-litigation litigation. It is an additional rung for lawyers to have fun at and for judges to scream at arrears, because it is full pre-litigation and then the real litigation starts after the award. Gram Nyayalayas have hardly taken off in number terms. The real success story, if you look purely at numbers, is Lok Adalats. And that has now done the fantastic figure, I am told, in May 2023 of almost 21 crore disposals. That is 200 million plus disposals. That is an achievement, but we all know the limitation of Lok Adalats. Petty claims, land acquisition, motor vehicle accident, etc., etc. It doesn't apply to a lot of other categories. Where comes the fourth area? And today, India, from September 23 onwards, has a world-class, truly a world-class Mediation Act, a new act, state-of-the-art. And this is the time, we don't have figures available for it, indeed for arbitration or mediation, as we do for Lok Adalats. But this is the time to move up the ladder and get the best results in mediation and conciliation with this act. For corporate matters, for high-stakes matters, for medium matters, for diverse matters. I don't have time. I spoke in USA at Pepperdine University, the home, the Mecca of mediation, on this new act. I don't have time to do that now, but if you look at it, you will see that it has all the infrastructure and concepts which are required. It's only that the Indian genius of judges and lawyers have to put it to good use. Friends, the next point is about, and as you can see, I am following my self-imposed limitation of being a fan dancer, touching upon topics without really covering them. Delayed justice must also be seen as the most egregious and unpardonable form of human rights violations. There cannot be a worse form of human right violation, because delayed justice applies as much to criminal as to civil. There are 6 lakh under trials languishing for more than 5 years, 7 years in jails. The jails are supposed to have, in many cases, of course, 4 times the occupancy, but on an average, twice the permitted occupancy, on an average. I have the details, but don't have the time to give you the state-wise breakup. We have never, you'll be astonished how petty we are. Bail, something like bail, has 81 types of filing and registration in all the high courts put together. Different names, different nomenclatures, different styles. So you can't even do a comparative survey. You'll be even more surprised that although happily I am told the average disposal time for bails is only 23 days. But there are states like Jammu and Kashmir where it is the average time is 156 days. We're talking about bail applications. Odisha was 61 days, Mumbai was 56 days. These are about 2-year-old figures, 1.5 years old figures. We have not experimented with new ideas, for example, like GPS-enabled anklets. A large number of under trials and people behind bars don't need to be there. You achieve exactly the same result of flight risk, tampering, etc. by GPS anklets, which countries less developed than us are using effectively. That's why I said you need to think out of the box and take these bold steps. As Chief Justice Ramanna said, it is certainly not the judiciary alone, and I'm not blaming the judiciary at all by itself. There is a failure in every sector, every segment, every organ. Take, for example, the government, the biggest litigant. We don't know it's 60%, somebody says it's 70%, it is at least 50% of the litigant in every matter, possibly 60, 65. There are every few months, or every few years rather, a litigation policy published by the government. The litigation policy gives you long, big sermons. Just a few years ago, I had a remarkable experience and I told the Supreme Court arguing a matter. Some litigation policy came a week before my matter reached the Supreme Court, or 2 weeks before, which said that if the government loses an award, which includes public sectors, 75% of the award amount must be paid and then the government must appeal. Because they found a large number of companies with award in their favors who were going to IBC because they didn't get the cash. Because the government would challenge and the matter would languish. 2 weeks after that, no less than the Attorney General appeared asking for a 100% stay. So I pointed out the litigation policy of the Government of India. They said, but that may be different. This is an individual case. So nobody follows these litigation policies. I had the privilege of serving as Additional Solicitor General in 1997. And I became an expert in 6 months on reading between the lines as to why a file has come to me to get approval to file an appeal, or why it is done for getting my stamp of approval for not filing an appeal. Because the officer wants to save his backside. So we need to have actual people on the ground with broad shoulders or shoulders broad enough to implement these litigation policies, which come every 1 or 2 years and are thrown into the dustbin. Ultimately, don't forget, friends, it affects not only human rights. The biggest crime becomes poverty, not the crime you're accused of. They suffer the most. But at the other end, it affects business efficacy, commercial efficiency, predictability, closure, stability, certainty. It is the antithesis of a desirable business environment. I have a chart here which shows another malaise. Delays, as I said, are caused by multiple things, not one. And this delay which I'm going to tell you about now is something we don't even notice. You know, an important issue of law, actually by reference and re-reference from a division bench to a 3-judge bench, from a 3 to a 5, and sometimes from a 5 to a 7, takes 10 to 12 years to travel. Lalita Kumari, a case we all know about the registration of an FIR, travelled from 2008 division bench to 2012 5-judge bench and finally got decided in 2014. Now the law is settled in 2014, but the law was settled earlier in Lalita Kumari on 2008. Between 8 and 14, 6 years, the poor high courts must have spawned a progeny of at least 1,000 cases following the 2008 judgment, or being confused whether to follow the 2008 or the later 3-judge reference. This is how we create litigation. It has happened in many cases on the reinterpretation and the comprehensive judgment on 319. Hardeep Singh starts somewhere in 2008, ends up in 2014, same years again. Subramaniam Swamy on the issue of prior central government approval in criminal law starts in 2005 and ultimately gains certainty in 2014. In between, you have a huge number of high courts and district courts struggling with the uncertainty of law, and that's a huge arrears addition which we don't even notice. Friends, I'm going to finish shortly, but I'm going to be a little bit above time, about 5 minutes more. There are, of course, good things happening. But the good things are happening, as I said, because there is a syndrome of many Indias in one. India is never one, many Indias in one. Supreme Court is a different India, and the high courts and the district courts are a different India. In Supreme Court, we have had recently a lot of things happening. It's the heaviest apex court in the world. But, you know, over 1 lakh or over less than 1 lakh, etc., is nothing compared to the 5 crore cases we are talking about. So really, we shouldn't be spending much time in the Supreme Court, though I must tell you that the recent initiative of dealing only with non-miscellaneous day cases, NMD, reduced a bulk arrears by 4.83%, which is a pretty good figure. The case clearance ratio, which the Supreme Court has decided now, which is more disposal than filings, reached 106%. You've had an accelerated reform in the registry for verification, curing of defects, prompt listing, minimal mentioning or zero mentioning with email mentioning only. And you have involved management techniques like the Center for Research Planning, a Supreme Court research wing, which has a 30-member team which has analyzed 10,000 cases and made down uniformity standards. You know, uniformity is another minor thing. But in India, you have, now of course they say that there should be only 48 categories and 182 subcategories. That's the new norm. But otherwise, across the high courts, you have a bewildering array of different categories. You can't have a computerized assessment at ease. Friends, the criminal justice system, as I said, the crime becomes not the crime you are dealing with, the crime becomes poverty. Apart from 33%, one-third judges in the High Court and one-fourth in the District Court, did you know that at all times 22% in the police forces seats are vacant? 22% in the police forces means 5 lakh seats are vacant. A large number of them are the supervisory, technical and senior positions, because the constable level has 80% occupancy. But the vacancy in the higher levels is 35%. You have a shortage of one-third, 33% in prison staff. You have a jail overcrowding in the last 10 years has increased from 18 to 30%. I'm not trying to just throw figures at you. The figures are not important, the message is. The underlying message is clear that how do you solve crime? How do you deal with crime and delays and backlog? And remember, 90% of this, probably 95% of this, affects the poor and the marginalized. That's why I said those behind bars in that category are not really guilty of the crime they've committed, but they are guilty of the crime of poverty, which is something. As they said, our courts are like fine wine. Some can say that they improve with age. But honestly, justice delayed for decades can rarely taste sweet like wine. The Daksh, a Bangalore research project, has shown that 55 to 60% of all times of the lower judiciary is spent in doing routine work on a particular day, administrative routine work. That is over half, that is 60%, that is like issuing summons, giving dates, no substantive work is done by 60%. Each court has about 90 cases on an average adjourned every day, 90. 50% of district courts have no VC on their desk, enabled and functioning. In many states, the shortage of judicial staff is 50%, but the average is 27%. I mean, I could keep on giving you shocking figures. None of these requires any great study or rocket science or genius. It requires hard-nosed, nitty-gritty implementation. So friends, as I end, let me say that the health of a democracy is not measured by the grandeur of its courts, and we have some very, very grand buildings, but by the speed and fairness with which justice reaches its people. We have to change our entire perspective and follow Gandhiji's dictum, customer is king. This system is not for you, the potential lawyer, me, the current lawyer, or him, the judge. This system is for that customer, the litigant. Gandhiji called him customer is king. That perspective has to change. The litigant, more often than not, that customer wails. He says, दोपहर तक बिक गया बाजार का हर एक झूठ, दोपहर तक बिक गया बाजार का हर एक झूठ, और मैं एक सच को लेकर शाम तक बैठा रहा. Every case resolved promptly is a reaffirmation that the law exists for citizens and not the other way around, that the citizens exist for the law. If we do not pull up our socks, indeed our shoes and legs, we are going to suffer from Iqbal's famous and unforgettable words about the unpardonable sin, he said, "एक ख्वाब ऐसा देखा था ताउम्र नींद आई, एक ख्वाब ऐसा देखा था ताउम्र नींद आई, लम्हों ने खता की थी, सदियों ने सजा पाई." Thank you very much. I think I can save myself a walk by just walking across here.
Thank you so much, Dr. Singhvi. Delayed justice as a form of human rights violation. That is a very thought-provoking thought indeed. Do stay with us on stage. We are now moving to a fireside chat on constitutional morality and the future of Indian democracy, a timely and vital discussion, I'm sure you'll all agree. Joining us on stage to moderate this dialogue is my colleague, T.M. Veeraraghav.
Thank you very much, Dr. Singhvi. Your fan dance was so good that we thought we'll make you do a little bit more of it sitting down here for 10 minutes or so. You've spoken as a jurist. Of course, this fireside chat is about constitutional morality and the future of democracy. So I'm going to try and wake up the parliamentarian politician as well as part of this conversation. You know, when we speak about constitutional morality, sir, in a sharply polarized political environment, has the definition of constitutional morality and the understanding and the debate around it become so politicized? You say tyranny of the majority. At least the majority in parliament turns around and says, look, this is a political allegation.
So,
No, I think you can go ahead.
can you hear me?
Yeah,
Can you
now-
hear me? Yes. Let me start by saying that when we talked about this fireside chat, you rightly told me not to look at anything and we just have a conversation. The only word you mentioned was constitutional morality. So you have asked actually a political question based upon a completely philosophical and legal concept called constitutional morality. So let me take 1 minute to explain to you what the constitutional legal concept, then we come to the politics of it. You know, Ambedkar, Dr. Babasaheb Ambedkar, used evocative words by saying constitutional morality is not a natural sentiment. It has to be, I'm quoting him, it has to be cultivated. We must realize that our people have yet to learn it. Democracy in India is only a top dressing on an Indian soil, he said. Democracy in India is only the top dressing on an Indian soil, which is essentially undemocratic. Now, constitutional morality, to take half a minute more before I come to a political question, is really a concept of the Greek historian Grote in the 19th century. And he said it is an indispensable condition of government to diffuse constitutional morality. But what does it mean in law? It means the spirit of the Constitution. It means the silence of the Constitution. It means the architecture and scheme of the Constitution, not the text. And it means that those who are holding public office act with a particular and requisite set of virtues which can't be looked at to be found in the text of the Constitution. So you can see that it's a very abstract, bona fide concept about real good governance. Now, having said that, as far as theory is concerned, your question is about majoritarianism versus lack of majority, versus the opposite view. Let me start by saying this is not about questioning the majority's right to govern. Democracy is defined as rule by the majority. Churchill famously said that democracy is the best form of governance amongst all the worst forms which we have. So it is not a good form, but it's the best available form amongst the worst forms. Now, the crux of the point we miss in terms of constitutional morality is that while the rule of the majority is the meaning of democracy, constitutions are created only for the purpose of entrenching a large number of rights untouchable by the majority. Why would you have a constitution if you had majority rule? The whole idea of a constitutional document is when it says part 3, fundamental right to free speech, fundamental right to trade, this, that and the other, to life and liberty, to religious freedom. These are all anti-majoritarian rights. The very reason our founding fathers spent 3 years in creating them and entrenching them was to protect every citizen, whether or not he is part of the majority. Whether or not he is part of the majority. Otherwise, every one of these rights can be overridden because you have a majority. So therefore they said, first, some rights are necessarily anti-majoritarian, they need protection against majority will. Second, those can also be overridden, but by special majorities, 2/3. Third, there are some rights which even 100% of the legislators cannot change. Why do you have basic structure? I declare tomorrow that this shall not be a republic but a monarchy. I declare today that only blue-eyed babies shall have the vote. Why can't I do it? I have 90% of the vote. A very good real example, real life example, is the NJAC. We don't have consensus, or we have a fractured consensus in Parliament. Not even a statute can be passed because we are fractured. But on the NJAC, there was 99% voting, 100% in the Lok Sabha, and 99.9% only Ram Jethmalani got up and voted against. Why was it struck down? Majoritarianism, no? Why was it struck down? These very people struck it down because they are the guardians of the Constitution who are supposed to uphold what they think. Of course, they can be wrong, but they are entrusted with the job of declaring what they think is against the basic structure, and they found that judicial independence is part of the basic structure, and NJAC goes against judicial independence. I'm not debating the judgment. I'm giving an answer about majoritarianism. There is no such thing as majoritarianism simpliciter in a constitutional republic.
No, the point taken, sir, that the courts have always been the custodian of ensuring that the constitutional values and the basic structure is not tampered with. But I'm coming more to the political argument today in terms of trust in the system and trust in the whole process. When there is an attack on the question of the Constitution and whether it is under attack and whether constitutional values are being followed or not, when there is such a fierce political atmosphere in terms of questioning that, where does that leave us in terms of what is right and what is wrong? How do we trust, for instance, that the opposition is not using this argument for electoral reasons?
That is the dialectics of democracy. The dialectics of democracy is that you will not write the script for me and I will not write the script for you. Ultimately, now you have asked a political question, I have not, but this is a political session, so we have to speak politics at some point of time. According to me, there is a trust deficit never seen in India as seen for the last some decades. I may be wrong, I may be minority of one, that's my view. That trust deficit is created by a variety of reasons. We don't have time to go into it. According to me, there is a weakening of the non-institutional pillars of Indian democracy. One pillar is secularism. Another pillar is federalism. A third pillar would be all the other non-institutional virtues like fraternity. Then there is a further weakening of the institutional pillars of Indian democracy. According to me, there is a weakening in the judiciary, there is a huge weakening in the media. Maxim is in probably your sector. And, Advaniji would never have thought that his sentence said during the emergency may be temporarily true. We asked you to bend and you crawled. Is possibly 10 times more true today. So, therefore, these are realities whose job is it to reduce the trust deficit, whose job is it to uphold the non-institutional pillars of Indian democracy like secularism, fraternity, federalism, whose job is it to ensure that the pillars of our constitutional system like the army, the CAG, the election commission, the judiciary are imbued with constitutional morality? Well, I think everybody, but above all, the government of the day.
Important point that you're making there, and I'm just being told that we are really short on time. So I just want to bring your attention very quickly to the 130th Constitutional Amendment Bill that we had discussed as well, in terms of people who occupy offices despite facing cases. Now, there is a fierce debate going on into that. Do you believe that the abuse of office or the unwillingness to leave office is something that has led to an amendment of this nature that is essential as is being argued by the government? Or do you believe that there's another side that we're missing in this argument?
Well, I have already written about this. I've been interviewed on this by more than one leading newspaper, and I've spoken about it. And you should please discount everything I say because I belong to a political party. Having given those caveats, let me tell you that this particular proposal is all bunkum. Bunkum is the mildest word for it. You are not going to infuse any constitutional morality, which is the duhai you are giving every minute, by having those arrested for month, 31 days, leaving their constitutional offices. Number one, we know the reality of the power of arrest without the 31-day limit. We know the judgments in theory of the Supreme Court, in law and jurisprudence, and we know the practice on the ground in fair statutes like PMLA, in the IPC and now the BNSS. With that kind of arrest jurisprudence, if you are telling me that a 31-day arrest leads to the departure of a constitutional post holder, actually you are negating democracy completely. This is for a completely different motive. You've asked a political question, so I never hesitate to give you a political answer. The motive is clear that you are able to control, overawe, threaten, intimidate, scare, create an ambience for everybody who is any manner opposed to you. That includes your allies. That includes even your own governments in states. Because a 31-day arrest amounts to letting a constable nullify the essence of electoral democracy. Chief Minister, Deputy Chief Minister, Minister be damned. This is completely anti-democratic. I hope and trust the JPC will not pass it, despite many parties boycotting it. I hope and trust that better sense will prevail, but this is going to be an example of majoritarian rule, but with one caveat. This requires a constitutional amendment. So you'll find out whether the two-thirds and other theories of majoritarianism will apply here or not, as and when it comes back from the JPC into Parliament.
It's a point that we could discuss forever. There are multiple arguments for it, but unfortunately we've run completely short of time and the fan dance has to end here. But I just want, there are lots of students out here. What do you believe is the key value that they need to inculcate and as they become part of a system that defends and perhaps perpetuates the constitutional morality that you will hand over to them?
If you are talking of the Constitution, or as legal law students, and the constitutional book is the Gita and the Bible for them, I think all that they need to do, partially, incompletely, faultily, is to keep reading the 5, 7, 10 words of the Preamble and see to what extent they can inculcate those values. That's the best answer I can give as far as jurisprudence is concerned to law students. Not the political rhetoric. For example, take secularism, one of the most abused words. And I entirely agree it's abused by all sides. The essence of the spirit is different. Professor Bhargav of Harvard University put it very well. He said, in Lincolnian terms, he said, Lincoln used this term, by the people, for the people, and of the people. Then he writes in the next sentence, we can understand by the people because they elect. We can understand for the people because they elect. Right. Why did Lincoln say of the people? He was defining secularism. So he said of the people is supposed to convey a sense of co-ownership of democracy to every human being in a particular system, to the last man in the last row, that sense of co-belonging and co-ownership. Now that's the spirit part of it. And same applies to our least noticed word in the constitutional preamble, fraternity. Actually, secularism and fraternity are partners, whether partners in goodness or partners in crime.
Right. Thanks very much. On that note, Mr. Abhishek Manu Singhvi, we leave this conversation here for want of time, but a fascinating conversation both from a legal point of view as well as the political realities.
Thank you so much, Dr. Singhvi and NDTV's TM Veera Raghav for that compelling conversation. We now welcome to the stage Honorable Justice Sanjay Karol, Judge of the Supreme Court of India, to deliver a keynote address on the evolution of law to accommodate evolving socio-economic realities in contemporary India. A round of applause, ladies and gentlemen.
A very good afternoon to all of you. We have, I can see in the audience, my senior, my former colleague, Honorable Justice Deepak Gupta, Mr. Singhvi, Mr. Chakradhari Singh, learned Vice Chancellor, and young students who are present here. We have people from the media, especially Mr. Bhargav, who was really got me here. I shall be speaking briefly because we are running out of time. Friends, I have to share certain thoughts with you as to how the Constitution has progressed in sync with the changing times and socio-economic values. It is both a pleasure and a profound honor to address you today in this August gathering. I firstly thank the SRM Institute of Science and Technology and their partners for creating a space where judges, practitioners, academicians, journalists, and students can reflect together on the law's evolving role in a rapidly transforming society. We gather at a moment of intense change. The questions of our age no longer sit comfortably within the old doctrinal boxes. They lie at the intersection of law, technology, constitutional values, and ethics. But above all, they raise a deeper question. What kind of republic are we becoming? And what principles must we defend to preserve the idea of India? The Constitution, in this sense, is not only a legal document, but also an ethical statement, a compact between the state and the people. When Dr. Ambedkar presented the final document on 26th of November 1949, he gave us more than rules of governance. He offered a vision of dignity, liberty, equality, and fraternity. Mr. Singhvi was just speaking about that. These values were drawn from the deep ethical currents of India's history. But as Ambedkar himself reminded us, however good a constitution may be, it will be only as effective as those entrusted with implementing it. It is not self-executing. It comes alive only when its values are practiced in courtrooms, in classrooms, in the media, and the halls of the governance, as also the streets of this great nation, which is India. Consider how constitutional principles have guided us in the moments of crisis. In Keshwanand Bharti, all of the law students are familiar, the Supreme Court safeguarded emergency by articulating the basic structure doctrine. During emergency, the judiciary faced the agonizing question of whether liberty could be suspended in the name of expediency. And more recently, during the pandemic, when migrant workers were left stranded, courts were compelled to translate rights into concrete reliefs, be it into food on the table and buses to carry families back home. The episodes remind us that our Constitution is not a relic of 1949, but a living compass. As a judge, I have seen how these values acquire meaning only when they are translated into practical remedies. When a villager understands the scheme to which he or she is entitled, or when a small businessman can enforce a contract without ruinous delay, constitutional value move from abstract into lived experiences. Law that remains distant or overly theoretical does not serve the person standing outside a courtroom seeking redress. So we have to reach out to those who do not have access to justice. Today, technology is perhaps the most powerful force reshaping the compact. India is rightly a digital pioneer. Aadhaar is the largest biometric ID program in the world. UPI has revolutionized payments. Artificial intelligence is entering governance and even the administration of courts. But technology is never neutral. It can empower, but it can also dominate. Facial recognition systems in policing, for example, may help detect crime, but what safeguards prevent misuse or profiling on grounds of caste, religion, or appearance? The Supreme Court's Puttaswamy judgment affirmed that efficiency can never come at the cost of dignity. And let us not forget the villager who goes to collect rations and is denied food because of a fingerprint does not match the machine due to the age of hard labor. The law must ask who bears the responsibility when technology denies a fundamental right. Technology, in my considered view, also intersects with freedom of speech. Social media has democratized discourse, but it also became a platform for hate speech, misinformation, and disinformation. During the farmers' protest and the anti-CA demonstrations, digital platforms became arenas of democratic debate, but also of censorship and manipulation. Here, the ethical challenge is twofold. The state must therefore protect the right to dissent. I emphasize the right to dissent, but citizens too must also exercise their rights with a sense of responsibility. These tensions extend to the media, which we often describe as the fourth pillar of democracy. At its best, the press has held power to account, as is in the exposure of 2G spectrum scandal or the Vyapam scam. At its worst, it has amplified hatred, distorted facts, or reduced public debate to noise. Yet, journalism is not only about national scandals. In my considered view, across India, local reporters have uncovered corruption in panchayat contracts, exposed environmental violations, and given voice to communities otherwise unheard of. These aspects of local courage strengthen the republic as much as any national headline. The real challenge today in the 24-hour news cycle and the temptation of sensationalism is when the race to the first overtakes the responsibility to be accurate, democracy itself suffers. The ethical obligation of media is not to echo the loudest voices but to amplify the truth, however inconvenient it may be. The Oscar-winning film Spotlight, based on real investigative reporting, is a powerful reminder of how patient, ethical journalism can shake the entire institutions and restore public trust. Friends and faculty, universities too are crucibles of constitutional values. Our law schools must impart technical knowledge but also mature moral imagination. When students protest fee hikes or social injustice, they are not politicizing education, they are living the Constitution. Ambedkar, Nehru, and many freedom fighters were once student activists. To silence campuses is to dull the ethical imagination of the Republic. Think of the JP movement of the 1970s, which reshaped Indian politics, or of recent campus debates on gender justice, climate change, and the digital platforms which mirror larger constitutional dilemmas in society. Even a moot court exercise is not merely an academic routine. It is a rehearsal of arguing for liberty, fairness, and accountability. Popular culture again reflects this spirit. The film Rang De Basanti captured the energy of the youth, which transformed from students into torchbearers of civic responsibility, reminding us that campuses are often the Republic's conscious keepers. Law schools can extend their role further through legal aid, clinics, pro bono drives, and research projects that shape policy. When a student helps a poor worker on the street recover unpaid wages or contributes to drafting a framework for better legislation, student becomes co-authors of the Republic itself. Above all, our courts and commissions must act not only as adjudicators of dispute, but also as custodians of constitutional conscience. From Keshwanand Bharti to Vishakha to Navtej Johar, the judiciary has been shaping a force in our Republic's journey. Yet credibility rests not only on landmark judgments, but on the everyday fairness of the system. A delayed pension, an unlawful eviction, or an ignored grievance often erode public trust more deeply than a constitutional crisis. For an ordinary citizen, justice delayed is not an abstract principle. It is a denial of meal, a lost roof, or a broken dignity. Sometimes this struggle becomes so absurd that it demands the attention of popular cinema. Many of you may have seen Kagaz, the film in which a man spends years proving he's alive after being declared dead in official records. Though dramatized, it reflects a harsh reality of public life, that when bureaucracy fails and justice is delayed, a citizen is reduced to pleading for recognition of most basic fact of his existence. For such individuals, the Constitution is not an abstract text. It is a difference between invisibility and dignity. Likewise, Article 15, another movie, reminded us that constitutional values of equality and fraternity cannot remain confined to courtrooms. They must confront the lived realities of caste discrimination and social exclusion. These cultural narratives resonate because they echo the struggles that courts and laws must address every day. The task before legal institutions is immense. Case backlogs demand robust case management. Digitalization of filings and hearings can improve access and transparency. ADR mechanism can reduce burdens and empower communities to resolve conflicts on their own terms. I'm saying this in particular because you as law students can help us reduce the backlog. What then anchors us in this complex landscape is the question which I ask myself. The answer lies in ethics. We need constitutional literacy, not as a rote recitation of article numbers, but as a deeper understanding of the architecture of rights, remedies, and responsibilities. We need humility, for the law rarely produces perfect answers. And the wisdom of the litigants, experts, and dissenters enriches the process. And we need a spirit of service by institutionalizing legal aid, pro bono work, and community outreach so that the justice becomes routine and not the exception. Friends, I must share this, that there are just a few percentage of the citizenry of this country has access to justice. We must reach out to those who are left out of the system, let them know about their rights and the remedies in law. Ethics is not tested only in grand moments. It is tested in a small daily choices. A lawyer tempted to choose a lucrative client for a pro bono matter, a journalist tempted to publish before verifying, a judge tempted to prioritize speed over fairness. These are the real battlegrounds of integrity. Ethics is not a luxury, according to me. It is an oxygen of democracy. Looking ahead, the frontiers of law will extend to climate change litigation. I shall not speak much on this climate change litigation because I am told that the others are there who shall be speaking on this. But I must inform this august gathering that what is happening in the northern states of India is absolutely agonizing. The regulation of artificial intelligence and governance of digital public infrastructure is need of the hour. These are challenges where law and ethics must walk hand in hand. Nation building, according to me, cannot be seen as the work of the government alone. It is the hard enterprise of the thought, speech, courage, and conscience. Courts interpret, but they also shape public norms. The bar advocates, but it also educates. Law schools teach doctrine, but also instill the spirit, public spirit. And one question was put to Mr. Singhvi in the last. I shall say that each one of us, every institution must instill and inform and appraise the students as to what patriotism and nationalism is in the context of the Indian Constitution. And we must imbibe that. The law schools, the media informs, but it must also preserve the truth. When these institutions collaborate, when legal aid authorities, bar associations, universities, and journalists work in concert, progress becomes possible. As we move forward toward the centenary of our Constitution in 2049, we must ask, will India be richer but less just, more digital and less human? Or will we be as a republic where technology serves dignity, institutions serve citizens, and the Constitution is not only read but lived at each moment, consciously by each one of us, wherever we are. The Constitution gives us the framework, but ethics gives it life. Let us measure our progress not only by GDP or digital strength, but also by the moral courage of our institutions and our citizens. This symposium is therefore more than an academic forum. It is an opportunity to design quadrilles for the technology, to renew the civic missions of law, and to make the Republic's promise real in the everyday life of its people. Let us leave this hall committed to ensuring that legal change advances human dignity and public good, as also public welfare. We can foster regulatory wisdom, broaden access to justice, and embrace innovation with suitable safeguards. We shall have served our Constitution well. Thank you. Jai Hind, please.
So, in a sense, we all have a role to play in the delivery of justice by asking the tough questions. Thank you then, Honorable Justice Sanjay Karol, Supreme Court of India. As you join the audience, could I please request the Chancellor and Pro-Chancellor academics to felicitate His Lordship. Sir. No, yes, sir. Okay, ladies and gentlemen, we now turn to a reflective dialogue on the soul of our Constitution, on constitutional values and the promise of justice. Please join me in welcoming on stage Honorable Justice Retired Deepak Gupta of the Supreme Court of India for a fireside chat on realizing the true spirit of the Preamble. He will be in conversation with my colleague T.M. Veera Raghav.
Thank you very much, Justice Gupta, for being here. I heard some of your YouTube videos on dissent and the importance of it and why it's necessary for new thought to arise. We will quiz you on all those points. My first question to you, sir, is let me begin with a broad question. What do we mean when we say realizing the true spirit of the Preamble? If there is an impediment to realizing it, what would that be in the present political context?
There are two aspects to your question. One is the present political context, and one I'll talk in what the Preamble means to me as a human being, as a lawyer, as a judge. The Preamble to the Constitution has adorned my office table from the day I became a judge. And I found that whenever I'm in difficulty in interpreting any provision, especially in constitutional matters, I read the Preamble, reread it, and I find my answers there. Mm-hmm. Because the whole spirit of the Constitution is embodied in the Preamble to the Constitution. We don't realize our founding parents were brilliant minds. And not over were they brilliant minds, they did not work in a partisan manner. For them, there was only one thing, that we have to draft a constitution, the best constitution we can draft for the country. And there was consensus by and large, there were differences. Obviously, when men and women meet and discuss, there will be differences. But they solved all these through dialogue. And that brings me to the second part. Dialogue is missing today. We are becoming a country of people who are not willing to listen to the other point of view. We are becoming a country which is intolerant, not only religion, I'm not talking about intolerant of another point of view. And for me, the essence of democracy is that, as you put it earlier, the right to dissent is one of the essentials of democracy. And you cannot have a dissent unless you have a dialogue. Obviously, it has to be non-violent. Obviously, it has to be civilized. But we can discuss matters and not brand each other as anti-nationalists or whatever just because we disagree on certain issues.
You've given me two questions subsequent to your answer. One is about yourself and the dialogue within you. Is there a personal anecdote that you can share of a judgment where you found it very difficult to come to a conclusion and then you read the preamble, and why reading the preamble helped you come to a conclusion?
Offhand, I can't think of one. There are many. If I remember, I'll tell you later. But offhand, I can't think of one.
An issue, perhaps, in which the preamble helped you formulate your point of view?
You know, you put a question to Mr. Singhvi, one of the last questions, when he said the preamble, what would you, and that was exactly what I would also say. You know, sometimes it's not very important issues or constitutional matters which matter. 90% of the litigants in court are not worried about the constitution. They are worried about their own dispute. A landlord with a tenant, a person has loaned money, he wants his money back. Somebody's been killed, the victim wants a fair trial, the accused wants a fair trial, and the victim's family wants him to be hanged. These are the matters. For 99.9% of the people, the Supreme Court is actually, I shouldn't be using the word, but actually inconsequential. It's the sub-judge, the district judiciary who matters to them. And therefore, in the Constitution, when we talk of equal justice, the first is justice, social, economic, and political. And justice can only be there if there is fairness. If there is no fairness, there can never be justice.
You know, I just began with, I hope you will remember some judgment that will give us a good anecdote, because that would be fascinating learning for the kids.
I think independent thought was one of the judgments.
Okay.
Independent thought, where the question arose whether because that was a case where I was in a dilemma for some time.
Okay.
Because could the court create an offense? Because that's not the jurisdiction of the court. You see, we said that if a man has sexual intercourse with a girl who's below, even if he be his wife, below 18, it could amount to
Correct.
which was rape, which was actually creating a... But then when I looked into, examined, and finally my answers came from these principles which lie in the Constitution.
Interesting. You know, when you speak of the independent thought, or even when you also talk of dissent in a sense, what's the biggest challenge before, let's say, a judge in ensuring the right to dissent is preserved, but at the same time not abused?
Absolutely. That is the balance which has to be struck. See, right of dissent, there can be no quarrel with that. Everybody has a right to dissent. But that dissent must be also expressed in constitutional ways. It also must be expressed non-violently. It also must be expressed, but merely because you criticize the powers that be, and whoever be it power. You see, irrespective of the political connotations, whoever is in power tries to protect their power. And nobody likes criticism. And if you don't like criticism, and being just following anybody and not criticizing is an anathema in democracy. We have a right to question. I think that's the basic right of every human being. Even if we had no constitution, wouldn't we have the right to question those who govern us?
You know, you started with saying that one of the problems is that we don't have dialogue anymore. We're averse to dialogue, if I can put it that way. Now, how does the right to dissent in an atmosphere where there is no dialogue lead to any kind of constructive progress? Because in your speech, and I'm quoting that speech, very, very interesting, because you say the right to dissent is right to life itself, because that's the way new thought comes about. Now, when the right to dissent is exercised in an atmosphere where there is no dialogue, does it then become just empty protest?
No, I don't think it becomes empty rhetoric, because why do you dissent? You don't dissent just for the sake of dissenting. I mean, if that be the so you're opposing just for the sake of opposing, that's not value-based dissent. Value-based dissent is when you talk of things, you see somebody is doing something and you don't agree with it. And then you say it in a very constructive manner, this is what is wrong with it, this is what I feel, the manner in which I feel it should be done. And that's, you've taken up I think from one of my judgments or speeches. But that takes me back to a judgment which I wrote when I was a judge in the Himachal High Court, related to one of these anti-conversion laws. And I said, and this is from the second part of the preamble, freedom of thought, belief, speech and expression. What is my faith is mine. Nobody else has any business whether I change my faith, whether I keep my faith. An agnostic, an atheist, a spiritualistic person or a religious person all have equal space in our constitution. And therefore, while delivering that judgment, I again drew inspiration from the second part, that the freedom of thought, freedom of belief, thought and expression. Now these are very important. Each one is important. And how can you, dissent flows out of those only. I think in the same judgment of the speech, if I remember, I've written, you look at the thinkers from time immemorial, whether it be Buddha, whether it be Jesus Christ, Muhammad, Guru Nanak, Raja Ram Mohan Roy, everybody questions what has happened earlier.
That's right.
If you don't question what has happened earlier, there will be no development of thought.
You're making a very important point and now I'm going to move from dissent to dialogue. And in the context of what you've just said, one of the most contentious words in our preamble today, at least politically, is secularism.
Yes.
How do we arrive at a common understanding of secularism? Because there are some who argue, sir, that secularism means keeping away from all religions. The others argue that it's about embracing all religions. Is it possible? Has it practically become a difficult word to reconcile with in a severely polarized system?
In a sense it has, you're right, that in the polarized system, when we look at it with intolerance, when we again look at this concept only, you see, I'm not looking at the French way of viewing secularism, that you totally, every symbol should be removed. That's one way of it. I think secularism, the answer lies here only. May I just...
You'll have to hold the mic closer, sir. Oh, you're holding the red book.
The answer to your question lies in the preamble itself. Because one of the promises we made to ourselves when we gave unto ourselves the Constitution was fraternity, assuring the dignity of the individual and the unity and integrity of the nation. So, fraternity is, as my friend Rohinton Nariman quite often says, this is one of the words of the preamble which has never been really looked into in a greater detail. What is fraternity? It's brotherhood. And brotherhood of all types of people, all castes of people, all creeds of people, all religions, all, a Hindu from Punjab, in certain ways, would be much more akin to a Muslim from Lahore than to a Hindu from Chennai. But we have to live together. And that secularism is, I would say, a need to respect that everybody has the right to have his own thought and belief.
I'm going to take you as an observer outside the courtroom as well. When you make this point, where do you think we faltered? Why do you think 75 years down the line, we've still not been able to have that value, or what we define from the preamble, become the cornerstone of political debate everywhere in the country?
I think it started with the Congress, when they used a particular religious minority as a vote bank. Now the same religious minority is being used to consolidate another vote bank. The problem rises when we try to, win elections on these grounds and not on real issues which matter, economics, living together. These are important issues.
The compulsions of electoral politics, you are saying, led to destroying the understanding of secularism over the last 75 years.
I think that would be to a large extent. I won't say that's the only, but there were many other factors. But this would be one of the larger.
No, a very interesting point that you make, because I want to bring your attention now to the other word that's often misunderstood or perhaps led to some kind of conflict, and correct me if I'm wrong. The other word is the integrity of the union vis-a-vis federalism and state rights. Now, do you see these two and demands for independence, which we are, demand for strong federal structures from states like Tamil Nadu or other, do you see them, challenging that, or do you believe that we're still insecure about the integrity of union in some way?
No, I think by and large we're secure of the security of the country. I think even with whatever differences we have, we all get together when times are difficult. It's not that when we face an outside aggression, we are always together. And that somehow always gives me, I'm an optimist, and that gives me optimism that things, these are passing times. As I said, it's more to do with elections. And when the parties realize that this is not working in elections, then they'll find some other thing to fight elections on, because over a period of time, people will also realize that this is not giving us anything. Right now, to be honest, it's all over the world it's happening. It's not only in India.
That's right.
The right-wing movement is happening all over the world. And I always believe that majority also has, if the minority has a right to dissent, the majority has also a right to, govern. So it's nothing wrong, but I only feel my problem with, which I said in my speech of dissent also, it's not that merely because somebody dissents, his view has to be accepted. My only thing is that he must be heard at least. You can't say that we'll not hear a person, or we'll brand him an anti-nationalist, or another term used very often nowadays is urban naxal or something. How do you do?
The reason why I asked you that question is that the compulsions of electoral politics sometimes builds narratives which may not be necessarily healthy and based on the spirit of the preamble of the Constitution.
Absolutely.
And is that a worry for you as an eminent jurist? I mean, when you hand this over, when you say the spirit of the preamble needs to be handed over to the students?
First of all, let me correct you. I'm not an eminent jurist. And I speak here not less as a jurist, but more as a student of the Constitution. And for me, it is worrying that, we say the word secular was never there in the Constitution. The word socialist was never there in the Constitution. And both of them were introduced on 3rd January 77, if I'm...
42nd Amendment.
By the 42nd. Now, as far as I can see, these words were introduced by Mrs. Gandhi just to give a very nice cover to some draconian measures which she was putting in by the same amendment. And, well, at that time, Mr. Kumaramangalam and all held the field, and they were leftists. I won't say communists, but they were leftists. And socialist, in that sense, may not be the term which should be in the Constitution, even I feel. But even if socialist is not there, when we talk about equality, justice, social, political, and economic, then economic justice embraces some element of being fair to the people.
Right.
When, and I'm just quoting Mr. Murli Manohar Joshi, who spoke a few days back at the RSS Conclave, that 65 or 70% of the wealth is in the hands of 5% of the people. Now that's not equality. We've, to some extent, in the first promise which we made to ourselves, we've achieved political, because one man, one vote has now become the rule. Okay, money, power, those are always problems. There'll be even in a very advanced society, there'll always be problem. Social media is a problem, or how to change minds. But both social justice has not been achieved. We still have honor killings.
That's right.
We still don't accept intercaste marriages, much less interreligious marriages. And economic equality, we are far, far away from. We may have overtaken Japan and become the third largest economy in the world, but that is by way of numbers.
That's right.
If GDP is taken into consideration, we are way down the ladder. A true country is doing well when most of the people are doing well. Not when a few of the people are doing very well at the cost of many who are not doing.
On that somber note, sir, I think we'll have to end this conversation because my producers say we're completely out of time. I wanted to draw your attention to some specific cases, perhaps after this conversation, but the big takeaway for me is when in doubt, read the preamble. It'll clear your doubts on whatever it is in terms of contentious legal issues.
I think even for the students, I have just one thing to say. Just when you read the preamble, it guides you, especially law students, it guides you in the manner you must deal with people, with yourself, and with issues.
And not just for lawyers, for everyone. Thanks very much there, Justice Gupta,
thank you
for
so much,
taking time
Raghav.
out to speak to us.
Thank you, sir. Do stay with us, sir, do stay with us on stage with us for a moment, sir. Thank you very much for your perspectives on the preamble and the answers it contains to our reality today. I'd like to invite Dr. P. Satyanarayanan, Pro-Chancellor Academics, to felicitate Honorable Justice Retired Deepak Gupta, Supreme Court of India. applause, ladies and gentlemen, for Shri Satyapal Jain. Okay, ladies and gentlemen, distinguished guests, eminent jurists, faculty and students, while the stage is being set for our first panel discussion of the day, I would like to remind you all that today's event, SRM Lexposium 2025, from the TP Ganesan Auditorium set on this marvelous campus is being live streamed on the NDTV 24/7 YouTube channel. So in case you need to leave, you don't have to miss out on some fascinating conversations and keynote addresses. You can watch them on YouTube as well. And if you let people in your family know that you're in the audience, they'll be watching too. We'll take a very quick pause to have the stage set. Right. We now move to our first panel discussion of the day, Law and Ethics for Viksit Bharat. As India looks toward becoming Viksit Bharat by 2047, the role of law and ethics will be paramount. This panel explores how legal institutions can serve as pillars for a just, inclusive, and globally respected India. I would like to welcome on stage Dr. Pinky Anand, former Additional Solicitor General, Pradeep Rai, Senior Advocate, Supreme Court of India, Professor Dr. Sri Sudha, SRM Institute of Science and Technology, and joining us virtually is Nalin Kohli, Senior Advocate, Supreme Court and National Spokesperson of the BJP. To moderate this discussion, please put your hands together for my colleague Vasudha Venugopal.
Yes. Hello. Hi. India today stands at a turning point. Economic growth alone cannot make a Viksit Bharat. We need to have an equitable society. Joining us now, one of my favorite lawyers, Pinky Anand, former Additional Solicitor General. We have Pradeep Rai, Senior Advocate. And also in the Supreme Court of India, we have Nalin Kohli also joining us. He's also an advocate, Supreme Court of India. We have Sudha P. She's the Dean, School of Law, SRM University. Thank you all of you for being part of this show. Pinky Anand, to you first. What are the main judicial reforms, ma'am, that you can think about that have taken place in the last 10 years, which have made justice accessible to all Indians? First of all, thank you very much for being here. I have actually, when I was coming up, we were just talking about how I have come from the NDTV studios to SRM campus, and indeed I'm delighted to be here. The subject, of course, being of immense interest, Viksit Bharat is the theme of the day. It indeed is a stage where the country is facing, where we are going up to 2047 to become, hopefully, if not the largest, the second largest country in the world. We are already on the third, as having gone past Japan. So what are the judicial reforms and what is the stages that we have gone through? I can identify a few of them, and there are several, by the way, so I can go on forever. I don't want to do that. But to my mind, one of the most major constitutional amendments that we have done, which has really brought national integrity into focus, is Kashmir. I think Kashmir and bringing of Kashmir and abrogating Article 370 is the biggest step that we could have taken, and we did this all the way back in 2019. Something that nobody could do, we have done, and Kashmir is back in the fold. It's another matter, of course, you have Operation Sindoor somewhere on the outskirts of what is happening, but bringing back a part of India within India and completely so that the laws can be accessed by all the citizens there. And incidentally, aside from laws, even the economic integrity, even the progress,
in all ways has gone across because the laws and the constitution applies to Kashmir. So that is one of the most major significant changes that we have done. Another one that I think I would like to highlight is in the nature of commercial laws that have happened. And that is across the board. That is the Commercial Courts Act. You have Arbitration Act, which has gone. Recently, you know, we've come into the Mediation Act. And I think that is one of the biggest steps all the students would know. ADR has become a big way of resolving disputes and accessing justice for all in a quicker, more efficient and more accessible way. So I think these features that have come in by way of the Mediation Act today and in fact the arbitration, India wants to be the arbitration hub of the world.
Right.
And we are going there. In fact, we have so much FDI into this country. You are aware that we are at this point of time a $5 trillion economy in the world. And we can't have it higher than that. So with this in mind, the international commercial disputes having arisen, we really want to put the focus on the commercial laws, the economic realities, and reforming. And lastly, just to flag another thought process,
Right.
I think women and gender, and ensuring that women and gender, in fact, I mean gender not only in terms of women, but I also mean the other sections, by the way. That's why I said women and gender into one class and all other disadvantaged sections. What we have been having is progress of laws so that equality and access go hand in glove with each other. So women in the realm of succession, property, women in the realm of criminal laws, to have the focus on the victim, women in the realm of economic progress, I think is something that we've been really focusing on, including in the way of, as far as the government is concerned, as also I must add in here that the judiciary and the government have been going hand in glove in going into this entire action.
Right. Thank you, ma'am. Nalin Kohli, the opposition says that the government has only been undermining institutions, the autonomy of institutions. He's right here. He's joining us on. So, Mr. Kohli, you know, when the opposition says that the autonomy of institutions is being undermined, and specifically with regard to, you know, what happened with the bail application of certain protesters, or for that matter, SIR, how do you look at that kind of criticism?
First of all, thank you for having me online. I'm sorry I couldn't be there physically, but I'm just recovering out of a viral. So I think, Masuda, you raised an important question. Let me first take off from where my friend and colleague Pinky said about Viksit Bharat or a developed India. Essentially, rule of law has to also keep pace with the progress of society. And that's why, if you will see, there's the removal of antiquated laws, there's cleaning up of it, there's a new criminal code so that you can bring in speed. Time requires law to keep pace with those developments. As we move towards becoming the third largest economy, we already have moved from the 10th largest economy in 2014 to approximately now the 4th, 5th, sometimes based on calculations of the currency, we are 4th, sometimes 5th, but we certainly are heading in the direction, as our Prime Minister says, towards being the third largest economy. Now, to answer your question, how can the denial of bail be a weakening of an institution? So I would say we have young minds in this university, they are law students. Let them go ahead and hear what those who have sought bail said on public forums, in open forums. What? That we of a certain community must keep out the others, or the other community will come on our terms into our protest. We will, with numbers, break India's link with the Northeast in the chicken neck, so that that is broken away. That is our area. This is not just an intent of secession. This is equally important, an enunciation that we will even do violence if required. Rule of law requires a peaceful society. Our constitution gives equal rights to each one of us, without seeing any difference of gender, male, female or otherwise, without any distinguishing between the religion of the Indian person. As an Indian, it doesn't matter whether we are Hindu, Muslim, Christian, Parsi, Jew, Buddhist. And India is ours. They are all now facing what? Trial under the UAPA and other provisions of law. UAPA is a stringent law. 5 times they've gone for bail. 5 times there has been judicial application of mind.
by 5 different benches, and each time they have felt, no, the material that is there is very serious. Time cannot be the basis to say that I have a right to bail. It is what you are being tried for. How clear is the material against you? Are you a threat to society? That's equally relevant. There's so much more that goes. Now, yes, in a democracy, the counter viewpoint can have a point of view.
Yeah.
We welcome that. But that doesn't mean that the institutions have become weaker. That is the view of someone saying that we have no faith in the courts. So you can't have it both ways. I have faith in the court when it gives bail. I don't have faith in the court when it doesn't give bail. So I think that should answer it. If you want me to speak a little bit, excuse me, if you want me to speak a little bit on the SIR, that's a separate subject. I'm happy to do so.
I'll just come back to you, Mr. Kohli, on that. Pradeep Rai, the other point, apart from dissent, is judicial accountability. And we did see that issue playing out with Yashwant Verma's case. Is Viksit Bharat in some ways compatible with the opaque system of judges appointing themselves? Is India the only country to do something like that? Why is the judiciary so hesitant in sort of accepting greater accountability when it comes to its own appointments?
You see, ma'am, what I suggest, first of all, I will respond to Mr. Nalin Kohli's this word, in which he said that 5 times UAPA court declined the bails. You see, if you are not able to file a charge sheet in 5 years, even still you think that there is a case against a person, you have to file charge sheet, you have to investigate. If you don't have the material, then you have to close the case. You see what happened to 2G case. Now I'm coming to your response. You suggest me any better idea in which, other than the judges appoint judges, which exist in any other country, especially in Indian circumstances. The problem is that if you give it to the politicians, still political clout works, still political interference is available somewhere. Many judges, they belong to different political parties. In the US, we have seen that many political persons were appointed as judges. But because there is no retirement age, so there is no undue influence over them. As far as India is concerned, Madam Gita Mittal is here. She has served as Chief Justice. They know that when they consider any name to recommend for the High Court Justship, they have to consider so many things. And mostly, I don't say that each and every appointment is correct. I will say that many appointments, you may raise an eyebrow. You may say something against that. But 90% or 80% appointments, I will say that is right. What in the first session was told, that you see, it may not be the best system, but there is no other better system available, especially in the Indian context. And that is the problem.
Okay, I'm very curious to know what Pinky Anand thinks of this, but let me go to Dr. Sudha first. Dr. Sudha, when we talk about simplification of India's legal procedures to make them truly citizen-friendly, there's one thing that comes up very often is the pendency of cases, 5 lakh cases. People say that only 60% cases get done in a year, 40% backlog. How are we looking at making justice affordable and also friendly? What kind of radical reforms do you suggest?
First of all, the first important reform we have to introduce in legal education is that establishment of clinics. Being an IP teacher, simply teaching what is the subject matter, instead of that, we have to give real-time problems and we have to train the students for solving these problems. And the second important aspect is that, like recently we have passed this mediation bill, like Pradeep Rai sir has rightly stated, we have to train the students not to pose the questions, but how to solve those questions, which means they should think like a critical thinkers for the purpose of addressing various problems which are coming up in the commercial field. And the third important aspect we have to introduce in the current day legal system is experiential learning. So today I am very much thankful to SRM IST by way of bringing learned experts. They are providing a first-hand opportunity to students how to think like a lawyer and judge like a senior judge of Supreme Court of India. Like that, what I am feeling is simplification of law is one important aspect. I think with the help of technology, we are translating laws so that even a common man is in a position to translate a particular provision, and he could be in a position to understand the nuances of law. But the only thing pending with us, the reason behind pendency of litigation is the government. Because out of 100 cases, 60% of cases will be appealed by government. If there is a change of attitude from the side of government, obviously, I am very, very sure in the coming years, the cases percentage will be reduced.
Right. Pinky Anand, you already spoke about reforms. I want you to talk to us about, this point that Pradeep Rai raised, no charge sheet but no bail after imprisonment of almost 5 years, and also the fact that what is the best way to select judges, then appoint judges?
Let's go to the second one first.
Yes.
I've been a strong proponent for NJAC. I think the National Judicial Accountability Commission that was proposed unanimously by the Parliament and ultimately was struck down by the Supreme Court is something that shouldn't have happened. Firstly, the Constitution itself didn't envisage supremacy to the Supreme Court to appoint itself and to have the process by itself.
Yes.
It was supposed to be with the President, and the executive powers were supposed to vest, and that's the way it was supposed to go. I personally intervened with the NJAC. I was appointed amicus, and we in fact proposed some amendments to that process, which ultimately didn't happen. This came after the NJAC judgment. But I think the reason for having something like NJAC and unanimous, and I disagree with Pradeep, everywhere in the world, you do not have judges appointing judges. You always have the systems which have a separate independent commission or separate committee which goes into this process, and I think it is the need of the hour. We've seen what's been going on, and I think it's high time that we brought in judges' accountability both in selection as well as in removal. I think the removal feature has also come up in the forefront.
Yes.
It's basically there before the public, and today we need something to account for. If a judge does something right or wrong, that is equally accountable as if a regular citizen does right or wrong.
Right. Nalin Kohli, where are you on this with respect to judicial appointments?
By paying my warm respects to Geeta Mittal ma'am. She's not just been an eminent jurist, but I think, there's one part of her that people don't realize. She was involved in Manipur on a committee. And during that time, she did an enormous amount of work in the camps, and even from personal funds, distributed guitars and other things just as part of the healing. And that's something to celebrate. I think there's much more than just only writing judgments. So I thought that was something we should bring to the notice of your viewers. Let's come to the two issues that have been discussed. So there is one on pendency, the others on appointment. On bail, I've given my views, the others have shared their views. Now let's come to appointment. There's a context to it. Earlier, or as it is under the Constitution, the appointment was to be done by the executive. Through emergency and after the supersessions that we saw, Justice Khanna and what happened thereafter, in the 70s, it led to the Supreme Court then evolving what is now known as the collegium system through multiple judgments. Now an argument can be taken that is it perfect? Well, actually nothing is perfect ever in anything in life. You have to keep working to improvement. Democracy has its own challenges, but do we dunk democracy? Do we put it into the dustbin? No. You have very good people elected, you have people questionable also elected. So this is part of how do we keep improving the system. We have from the same system judges who have been very eminent, hardworking. It's not easy to be a judge. I mean, I say it as an advocate. It's easier to be an advocate to do 5 matters, 6 matters, on a heavy day 10 matters. On an average, a judge has to deal with 50, 60, sometimes 100 matters. I mean, imagine the amount of work. Now, the argument can be taken that yes, the government is the main litigator, but a delay, and which has led to pendency, is an equally important part. That is also based, advocates take adjournment, the whole process allows that you must exhaust all your remedies, and if someone has a problem in law, if someone is prima facie guilty, they would like to exhaust all their remedies, it takes time.
Right.
But by and large, the Indian judicial system has been successful. Certainly there's scope to improvement. Certainly there has to be issues of accountability, as we've seen recently. But to run down everything is not an approach I broadly appreciate. I think a balance of everything has to be seen. The same system has produced excellent judges,
the same system has also produced questionable judges, as in any other place, the executive, say the legislature. So as a society, we have a stake and an expectation that we need to move in the direction of improving or cutting down the problems of the system that we are talking about. That's, the point that where I stand is about balance. Now, whether that is to be, Pinky says correctly, the NJAC was a very good move in that direction. It was unanimous. I sometimes wonder, can we have unanimity in today's parliament? That itself is a debate. It was unanimous by all the political parties. But yes, there was some difference of opinion between how the court saw it in terms of who would be the final say and how the elected representatives saw it. But I think we are back to a point where this debate is bound to acquire a little more momentum, and perhaps something good will come up in the future.
Right. Pradeep Rai, when we talk about balancing power and accountability, something that Nalin Kohli also mentioned, how can we strengthen the accountability of all democratic institutions, that Lakshman Rekha that we keep talking about between, judiciary, executive and the legislature?
You see, our constitution especially provides that there is a clear separation of powers. None of the branches should interfere in each other. And if they start interfering, there will be a disastrous result. In my opinion, even in NJAC or whatever it is, you cannot go just by because majority has passed something. There has to be rule of law, there has to be judicial mind applied, and there has to be, the basic structures has to be protected. In these circumstances, like there is a cricket match playing in the Pakistan, umpire is Mahmood Science and Sakur Rana or something, I remember those days. Those entire audience will say that Pakistan should be in fake, LBW decisions are wrong. Umpire has to be neutral. So ultimately, when these decisions are taken and when it is brought to the court, the scrutiny of the court, there has to be some fairness. You make a committee, you make a process, but that process should be entirely disconnected with the politicians. In my opinion, you select a process. There are so many good judges, you select. If you want to replace the collegium, you find out some 5 judges, 10 judges, 25 judges, whatever you want, and make a committee and let them appoint. Or if you want to have some other persons from the social sector, you take it from there. But you cannot have only the political persons deciding. One political party will decide in one way. Suppose today I am in not a good book, they will throw me out. So this is not a good idea. I personally feel that any provision replacing the collegium will be all right. But it is all right when there is no political interference, when there is a clear-cut, some kind of stability, integrity added into it. And you make a permanent committee, appoint the committee for 7 years, 10 years, they will be appointing judges. Why not? You come with that idea. There are so many committees where you have the privilege, but you don't appoint any Supreme Court Chief Justice of India for a committee to appoint. One more thing I would like to add. When I was entering in this campus, I found a statue of Raja Raj Chol. He was the founder of, not founder, but he was the main ruler of the Chola Empire, and thereafter Rajendra Chol, he took place. That was 984, and he died in 1014. And 1014 to 1044, Rajendra Chol was there. There is an incident when the entire public of a specific clan, they decided something, imposing their decision on this one family who belonged to other clan. And what happened? They called entire village and they said, no, you all are wrong. And they decided in favor of the one family. So whenever you decide earlier, what is our contribution in our democracy and law? Our contribution is only our sweat, only our labor. Land is not ours. Whoever got the land first, they did some sweating and they said, this is my land. You do some mining, you say, this is my mine. Ultimately, there is a law which has taken a place. And now you cannot have a system. You see, we are all growing. We are going forward. And when we are going forward, we have to have a system where we all work properly. We all know that what will be the outcome. If we do this, this will be the outcome. If we do not do this, nobody can do the other way.
Right.
Yes.
Dr. Sudha, you're also an academic. You deal with a lot of young students. Tell me, what do young people think about today's judiciary, legal systems? Are they optimistic about justice being accessible to everybody?
When I interact with youngsters, every time they are so positive. So what they will say is, with proper legal literacy, we can reach many downtrodden community. So that is the reason why at every law school, we promote legal literacy camps as well as legal aid clinics. But on the other side of the coin, few students, what they will say is the instant returns of their investment they are not getting, which means for the purpose of proving their success in the profession, they have to wait for 5 years. So that is the reason why few people are into practice, but the rest of them are preferring to work with solicitor firms as well as government organizations. Whatever the reason it may be, the law students, they have realized one important aspect in a way that rule of law is one of the most powerful tool for the purpose of giving justice to poor, helpless, and moreover, on the other side of the coin, because of corporate culture, many companies are in dire need of legal services. So that's why whenever I interact with law students, this positivity I have observed.
Right. Pinky Anand, your views on this and your message to young people sitting here.
I'll tell you one thing. We still live in a country where rule of law and the system of law, we all have ultimate faith in it. There is no question about that. Institutionally, we as a country have done immensely well for ourselves. Whether it is the court, whether it is public sector undertakings which are there, which do the work of the government, whether it is the government, but definitely any person will exhaust his remedies right up to the top court, and that is a saving, and at the same time sometimes a curse also, because it increases the number of cases. But I must share with all the students that our respect for the rule of law and this facet of life is something that keeps us alive with law, ethics and Viksit Bharat.
Right. Also, ma'am, in terms of number of women judges, that is shockingly, low for a country like ours. What do you think is the solution for this?
In fact, we discussed this subject. Recently there was a move by all women lawyers and who were taking this up with the government as well as with the courts to say we should have more. Actually, the movement is on. But I do remember what Justice Ramanna was just here when he was the Chief Justice. At the time, we were talking about 33% reservation, and then he was talking about it being 50%. But what was said at that time also is, you take in judges from the pool of lawyers and people who are available in the pool. So that pool has started growing also recently. We must be fair. I mean, in terms of number of percentage of women lawyers who've joined the profession, people who become into the judiciary, the lower judiciary, so that they can actually migrate upwards. You have that pool is small. So that pool has to be increased one. Right. Having said that, you have a second position where Chief Justice Nagaratna will become the Chief Justice in 2027, even though for a month. So the first time we are going to have Chief Justice of India who will be a woman, which leads the way. But the numbers is something which we really have to work on, and we are protesting with that. And we will all take up this protest universally. And what I understand is immediately after the protest, by the way, 2 women judges are appointed in the High Court just 2 days thereafter. So I think it's just a matter of process at times. The government is well conscious of it. Gender equality and gender sensitization and gender elevation is something that the government is working sincerely towards in all respects. So we hope to see the numbers increasing very quickly. I mean, Delhi High Court has been facing tremendous problem. We've had so many women division benches. Justice Mittal was there at some point, and of course then she migrated on to Kashmir and other states as Chief Justice. We've had women division benches, and yet at this point of time we don't. So these difficulties which we are facing, we want to get over. It's a protest time. So this SRM University and NDTV have to take this agenda together.
And I'm so glad you spoke about gender elevation, because that's important in all fields, right? Nalin Kohli, one of my last questions to you, what is your message, sir, to young people sitting here? And also you're a political person, I can ask you this. There is this battle over the Indian Constitution with every political party saying that it is the only party that is safeguarding the ideals of the Constitution. How do you see this battle? Do you think that this is also time to sort of, in some ways, have fresh interpretations of the Constitution while safeguarding its ethos?
That's a loaded question. It takes time to answer that, but I'll try to. I just again want to pick up something on what Pinky said. I think certainly there's enormous scope
for greater participation of women in every walk of life. I mean, there's no reason women and girls are doing so well at educational institutions and other places, and seeing more of them on the bench in the forefront of, work in the courts is something that I think all of us stand for. The second is, what's my message? I think be a good human being. That's the starting and the end of everything. If someone just sticks to principles and is a good human being, does what they have to do themselves, it's really serving the Constitution, it's serving life, it's serving society. Each one of us, everyone in this room, perhaps everyone who's watching the TV, is privileged in the sense that we have a roof above our heads, we have 3 meals a day. We don't have to worry about that. We don't have to worry about basic health care. And there are so many millions, billions more, who are facing challenges on a daily basis. The easiest way is to just, look out of your car. If you're traveling, instead of seeing straight, look at the footpath, and then you realize how blessed so many of us are with education, with opportunity, to be able to talk about gender rights, to be able to talk about our rights under the Constitution. So, when we work for ourselves, as we will in our professional lives, don't forget we should do something for society. Something that's not for us alone, not for glory. Justice Suryakant came up with a very nice quote, beautiful speech, and I'll request others to read it, where he says, your personal relationships will outlast your professional applause. Don't do it for the professional applause. That has its place. You will do it professionally, but do something for society, something which, as lawyers, we do pro bono, help another person in need. A small part of your time, you should dedicate it to that. Last question is on the Constitution. It's not a word. The Constitution is a living document. There's so much in it. Each word has import. There will be those who will argue and say, so many amendments, but that's why it's a living document. It evolves and it's able to accept those changes, keeping the basic ethos or basic structure in mind. It is interpreted on a daily basis by the courts, because that's what judicial review is about.
Right.
All we have to do is read that first chapter when we do, and people read part 3, they look at their fundamental rights, but don't forget there are equally fundamental duties. It's so well crafted. At one side, you have things that the state will guarantee, the other side that are desirable objectives. So when one looks at the Constitution, it's not under challenge. Institutions are there, the courts are there. The Constitution will keep evolving. We, by being responsible citizens, ensure that the Constitution achieves what it is meant to achieve.
Right. Thank you, Mr. Kohli. Thank you, Pinky Anand. Thank you, Mr. Rai. And thank you, Dr. Sudha, for joining us. Clearly, equality and fairness need to be the cornerstones of Viksit Bharat, and that should remain not just our commitment, but also our responsibility. Thank you so much.
Once again, Dr. P. Satyanarayanan, Pro-Chancellor Academics, to felicitate the members of our panel discussion. auditorium and for the students to also come back in from lunch, and perhaps you could start by occupying the rows in the front so that it doesn't look empty in front and crowded at the back. Also, as I had said in the morning, from my experience of being in classrooms, the professors always look at the back rows, not the front rows. So the front row is actually the safest place to be. Ladies and gentlemen, may I please request you all to take your seats. Our distinguished guests are about to join us. Our next set of speakers for Lexposium 2025 are about to join us in the auditorium. Could I please request you all to take your seats? And could I also please request those of you at the back to come a little more into the front so that we have a nice full set of seats for the guests to look at.
I could have opened with a good afternoon to all of you. But let me begin with a lesson on what is inclusion, so that it gets completely embedded in your minds and your hearts, and you learn to follow the same in everything that all of you do. So I will begin with 4 very universal greetings. Namaskar, Sat Sri Akal, Assalamu Alaikum Salam, Vanekam. They are relevant no matter what the time of the day you are, whichever part of the world you are, because if I was to say good afternoon to you, and we had viewers in Australia watching, it is probably good evening or good night. If it's the United States of America, it would be beginning of good morning, early morning there, and the same with South America. But just like the ethos of the beautiful mosaic that India is, a mosaic of cultures, languages, religions, our greetings are also universal, And therefore, I always use this example to illustrate as to how inclusive our community and our society is in even the way we greet each other. I have been asked to speak on access, defining justice and access, The thought process is that, the common thought process is that access to justice means access to courts. And my argument with all of you is that access to justice is not synonymous with courts. It is much more. Let me begin with a small story. I brought a written speech which I'm not going to read to you because there's lack of time and I have to time myself. You have to hear the wonderful words of Justice Anita Sumant, who is also time-bound because of a commitment in Chennai. So let me tell you a short story before I begin my address, a summary of my address. There was a case which came to me way back in 2007. It was a case which had been filed by a very poor person or belonging to one particular community whose house had been demolished in 1975, when very severe, very hard demolitions took place in a place called Turkman Gate in Delhi. And the government, realizing the error it had made, subsequent government later advocated a scheme whereby they were making allotments of properties to the people whose properties were demolished. This person had come to court that he had been identified for allotment of an alternative plot, but the government had failed to give him that plot. And he wanted the relief of being given the possession of the property which had been allotted to him. The government pleader on the other side, the municipal corporation pleader on the other side, vociferously argued that the property had been demolished in 1975. He had been identified for allotment in 1976, but he was coming to court only in 2007. And they said that delay and laches, you don't have the law of limitation so far as writ petitions are concerned. So he had come in a writ petition, and delay and laches by a petitioner in coming to court, delay in coming to court for relief, bars a remedy. Bars the remedy that doesn't exclude the relief, but that person is left completely remediless. So he vociferously argued that his case must be shunted out on relief and remedy. When in my discussion with the litigant himself, he couldn't even afford a very articulate lawyer. He barely could tell me that he had been running a small shop where he undertook the work of repair of furniture in a 7x12 tenement. And he, with his family of 6 children, also resided in the same place. So you can imagine the extent of his financial penury. And after he was thrown out of that place, he was on the pavement when some vehicle ran over him, and he was in a hospital for 7-8 years with hip surgeries, etc., etc. But what I want to tell you is that Turkman Gate is barely about 3 to 4 kilometers from the Delhi High Court. Between 1975 to 2007 is a period of more than 30 years. And it had taken a litigant 30 years to traverse the distance of 3 kilometers to seek justice, to seek relief. Now, why was he prevented from seeking justice? What came in his way was his financial penury. So, access to justice is not synonymous with courts, and people have to overcome many barriers, which include financial penury. There are structural impediments in the nature of victims of sexual violence and dangerous crimes having to depose, stand in court shoulder to shoulder with the perpetrator of the offense. There's a fear of legal institutions. There is an ignorance of law. Children have been hearing the expression legal literacy throughout the morning that I have, while all the time that I've been hearing here. And then there are societal barriers. The family will tell a girl who complains of domestic violence, no, try to bear it, learn to bear it. In North India, they use this expression that only your arthi can come out of your matrimonial home and stuff like that. There's financial penury. You saw this poor litigant, financial penury of women who gave up jobs to be homemakers, and then they are in a bad marriage and are compelled to go to court seeking maintenance, seeking divorce, all kinds of issues. So therefore, please understand that access to the courts is the last option for many people, and most people have to overcome a lot of these barriers before they can come to the courts. So what access to justice is actually overcoming all these barriers and then reaching courts mostly as a last option. Now, what is justice? Justice is the Republic's first promise. It is the word that opens our preamble, and it is the principle which animates our constitution. Our democracy draws its strength not from the lofty declarations, but from the access, the ability of every citizen to reach the law, to understand it, and experience it without fear or humiliation. I have often said that justice is real only when it reaches the last person in the queue. This conviction comes not from theory but from experience. As a judge, I have seen how distance, cost, language, even the very architecture of our courts can silence the very people the law was meant to protect. Philosophers have defined justice variously. Plato defined justice as a rational order. Aristotle called it fairness. Kant has defined justice as dignity, Rawls as liberty with equality. Yet, for the poor laborer who was turned away from a courthouse for want of a photo identity card, or the widow or the woman seeking maintenance whose case is adjourned for the 14th time, justice is not an abstract. For them, justice is voice, it is visibility, and it is timely access. The Supreme Court has repeatedly affirmed that access to justice is a fundamental right, both under Article 14 and 21, and it rests on 4 pillars: effective adjudication, geographic accessibility, speed, and affordability. Cognizant of these facts, of these issues, when I was in Jammu and Kashmir, there were several areas I found who were cut off from the rest of the country under 8 feet of snow and for long periods. So imagine women who were victims of domestic violence, what their plight would be. It was almost like a COVID-19 situation where you are locked into your home with the perpetrator of domestic violence. Imagine the person whose land is being taken away by a rich person because he knows that the person can't reach the court because of the snow. So in taking these people into consideration, we had designed what was called an Insaf Ki Dastak, that is knock-off justice. We had organized trained judges to run camp courts in these far-off places, and also enabled filing of cases in post offices in these periods of times. At the same time, there's been a program of creating special procedures for recording the testimony of vulnerable witnesses and those who are victims of dangerous crimes. Vulnerable witnesses include children per se, disabled people, persons who are witnesses in dangerous crimes, and also women who have suffered violence, of sexual violence or of any other kind. And this has been enabled the courts have been enabled to treat any person as a vulnerable witness. And testimony of such witnesses is recorded in a video conferencing within the court complex, but in a room, in a safe space where their dignity is respected and their special needs are taken care of and provided for, including a separate entrance to the courtroom, separate waiting area, food during lunchtime. And these have been significant steps which have enabled equality to these marginalized and these vulnerable victims who are very important stakeholders in the justice delivery system. You may not have heard of sextortion, but you have also all heard of the Me Too movement. It is where sex is used as a bribe. I'm using very loose words, using these expressions very loosely, as a bribe to lure people to do, women, it could be men also, to do certain things. In 2018, I had occasion to examine this issue in a complaint by women who were lured into sexual violence by a person under promise of jobs. And there we had advised the government to look at sextortion as an offense, and the Ranbir Penal Code, which was then applicable in Jammu and Kashmir, was the only code in the world where sextortion was statutorily recognized as an offense with a minimum sentence prescribed for it. So during the pandemic, we recognize, the special courts have recognized, these are all judicial interventions and judicial initiatives enabling access to justice for those in very, very bad need. But we had done an audit of cases where women and children were receiving maintenance under orders of courts, magistrates, and got the Social Justice Department of the government to extend aid and facilities to these petitioners and complainants from courts who had court orders in their favor or who had filed cases looking at maintenance. So therefore, and ensured continuity of payment of maintenance. Therefore, judiciary and lawyers can provide really truly meaningful leadership through judicial and legal interventions and initiatives. Commercial justice is a pillar of nation building. You can animate constitutional justice, credibility and efficiency in the court system and thereby animate commercial justice. Without a timely, credible dispute resolution system and mechanism in place, economic growth will falter. Singapore has been able to achieve the pinnacle of acclaim and recognition in the field of commercial justice, and therefore it is the much sought after hub for dispute resolution, and its arbitration and mediation centers are so busy and so sought after. If we reinforce our alternate dispute resolution mechanisms in the same way as Singapore has done and bring credibility to these institutions, then perhaps India can look at accentuating the economic growth by leaps and bounds. We have taken some measures. Pinky has pointed out the Mediation Act, the court-annexed arbitration centers are cases in hand. The case management has to be proactive. Judges have to take cases into hands and ensure that there must be structured and focused justice delivery and decision of cases, controlling adjournments for which lawyers can contribute a lot, all improve access not only to the system of people, but ensures justice, advance access to justice for people. Transparency has to be embedded. Technology must be a default. E-filing, online hearings, and secure digital records are a complete necessity. The one factor which I have strongly advocated throughout, even as a lawyer, as how to expedite justice delivery, is to prioritize perjury, contempt, and execution of court orders. These three things are not happening. Contempt cases linger for years, decades even. Perjury is hardly ever punished. Judges in routine pass orders that this will be decided where the final adjudication happens. And this has to stop. And costs should be proportionate to the judicial time which is wasted. So, Supreme Court has taken several steps in using technology as enablers. You would be aware of the use of SUPAS, which assists judges by analyzing case files, and SUVAS, which translates judgments into local languages, the English language. The legal profession is really a force for reformation. Those of you who have taken up law to practice must know that you are the spokespersons of the community, of the country. Lawyers are responsible for shaping India's freedom, and they have ensured huge developments in the evolution of the litigation and evolution of rights in the country. It is lawyers' initiatives which resulted in abolishing untouchability, securing gender equality, recognizing dignity and privacy for the third gender, and decriminalization of same-sex relationship. Beggary was decriminalized by courts, and sextortion recognized as an offense only because of lawyers' efforts. So the profession has to continue as a catalyst of reform. I had several examples from in the world over with regard to what initiatives have been taken, but I see that I am almost out of time. But a few words on what education, law education must encompass. The future of law and delivery of justice in India depends on education that transcends statutes. Lawyers of tomorrow must understand economics, climate science, data analytics, sociology, and public policy. If those of you who are reading environment law must be reading several cases which are titled MC Mehta versus Union of India. MC Mehta is a lawyer. You know, he's so committed to the environment. He's done phenomenal work. He's saved so many of our rivers. He's removed the tanneries from the banks of River Ganga in Calcutta, in Kanpur, and he's taken up several other causes. The solid waste management in Delhi, huge garbage heaps, if you go to Delhi, have also been controlled and not been permitted, the land thereof not been permitted to be misused by judgments of Justice Kuldeep Singh when he was in the Supreme Court. So lawyers must be problem solvers, negotiators, mediators, as much as litigators, policy makers, and as much as advocates. And above all, they must cultivate empathy. Justice is not delivered by law alone, but by the spirit with which it is applied, by the lawyer who takes up a pro bono case, that is a case free of any charge, the judge who listens patiently to an unrepresented litigant, the police officer who registers an FIR with sensitivity, the journalist who reports responsibility. Justice is a shared journey. It's not a solitary pursuit. Please remember that. When I was on the bench, my daily prayer used to be not as to God enable me to decide 30 cases, 40 cases, 50 cases. It used to be, God, let no litigant leave my courtroom with a sense that he or she has not been heard. I really feel sad that there are so many complaints today that we are not able to, the judge didn't even have time to give me a date in my own case. You know, this is really appalling. And my court master told me, just to give you a sense of what it takes to be in the court, my court master told me on a day when I had like 200 cases that, and you know, I said, why are you giving such long dates? He said, Judge Sahab, if I just pick up the file, open the file, give it to you, and you only give a date and you give it back and I tie it up, it takes 3 minutes. I have only 5.5 hours of court time in a day. And he said, if I gave a date of 3 months to every case, you would still have 70 cases on your board after the 3 months. So just imagine how much time is left on every case. So in conclusion, friends, justice is not a destination, it is a direction. One we must align ourselves to each day through the choices we make, the reforms we pursue, and most importantly, the values we uphold. Do not compromise on your values under any circumstance. Have the courage to tell the litigant that you are setting up a false case and I won't do it. The role of legal institutions is to chip away everything that is not justice, needless delay, avoidable costs, unexplained discretion. If we succeed, then both the last woman in the line and the last corporation in the land will say with confidence, India is where we seek justice because justice lives here. In other words, India is where access to justice is ensured and to every citizen. That, I believe, is the highest tribute we can pay to the law and the greatest service we can render to our nation. Before I close, my heartfelt gratitude to the SRM Institute and the NDTV for giving me this opportunity to travel to Chennai and speak to you. Access to justice used to be my mantra, and I can really go on for hours on this subject. I wish we had more time, but perhaps I'll come back another day, another time. And I'm especially grateful to all of you for giving me the chance to meet with such dear friends, such dear seniors and such dear friends. Anita is such a dear friend, and I'm so grateful that I'm getting a chance to meet her. Thank you very much. A good day to all of you. Namaskar. Listen, I see it's a very big gift. Can you have it shipped to Delhi or one of the colleagues? I have brought a very small.
We absolutely will, ma'am. Thank you so much for that very sobering perspective, actually, and reality check in a sense about access to courts and what that really, access to justice, I beg your pardon, and what that means for so many millions in our country, and also hopefully one of hope. But I'd like to now invite on stage Dr. P. Satyanarayanan, Pro-Chancellor Academics, to felicitate the Honorable Chief Justice Retired Geeta Mittal, J&K High Court. It's never too late to become a lawyer, says ma'am. But it's wonderful that the students gathered here are getting some fantastic perspectives from some of the best legal minds in India. And continuing that, I would now like to invite on stage Honorable Justice Dr. Anita Sumant of the Madras High Court for a keynote address on justice beyond the courtroom, exploring themes of accessibility, affordability, and legal awareness. Ma'am.
I will take a cue from Honorable Justice Mittal and dispense with the English greetings and go instead with Vanakkam and Namaskaram to Honorable Justice Rastogi, Honorable Justice Mittal, all the dignitaries in the audience, and most importantly, the students before me. Let's picture a courtroom. Not just any courtroom, but the ideal one, where the scales of justice are perfectly poised and balanced. On the one hand, you have the Constitution, etched with the promises of liberty, fraternity, equality. And on the other hand, we have the citizen. An ordinary citizen like you or me, but extraordinary in his or her uniqueness, seeking dignity and fairness. Now, access to justice beyond the courtroom, which is the topic that I am asked to speak to you about, is striking a balance between these two items that I just enumerated. That would define our democracy, or any democracy for that matter. Before I proceed, I should say that I am not an imposter, and that person there is really me, though that picture was taken perhaps close to a decade ago. The truth is that the balance that I spoke about just now is a very fragile balance, one which requires constant vigilance, courage, and innovation to sustain itself. As the previous speakers had said, each of these topics, I have just enumerated about 4 heads under which I'll make very brief presentations to you. And each of these sub-heads are in themselves worthy of a day's discussion. So you will pardon me for literally speaking, only scratching the surface of these heads. My talk to you is going to be just an inch deep and a mile wide. But pardon me for that. In the interest of time, that's what I'll have to do. The first point that I want to make is this. Though we speak of justice beyond the courts, this institution and all its stakeholders still plays a very key role in taking justice beyond the courtroom and in ensuring accessibility, accountability, and affordability. 39A of the Constitution states that there should be equal justice for all, and the weaker sections of society must have access to effective legal aid. Now, we have got legal aid authorities both at the national level and at the state level, at the district level as well, to oversee these. And these authorities formulate schemes, they spearhead the dissemination of the awareness programs, and they also ensure that maximum reach of the schemes is obtained. But all this will remain on paper if the implementation of these schemes is faulty, mechanical, or inadequate. Recently, we had a conference organized by the National Legal Services Authority. The topic there was conflict between human and wildlife. Not really access to justice, but if you look at it in that sense, human-wildlife conflict, everybody deserves justice in the larger scheme of things. So it's not just the human being that craves justice from the system, but all creatures of God who would have to be looked at identically or similarly at least. One of the themes in that conference was from resistance to resilience. And I thought that that phraseology was quite beautiful and a positive phrase because it captured the trajectory of development, facilitating measures that enabled overall development of all sectors. As Justice Mittal was saying, the judiciary, you would know. You would have read recent judgments where the Uttarakhand High Court has also passed judgments saying that rivers have got equal rights and animals have equal rights subject to the fact that all creatures must be protected, equally protected under the law. The dream is thus to move beyond being reactive to being proactive, anticipating iniquities and addressing them before they occur and before they start festering. This would demand a sensitivity that goes beyond one's close associations and a deep willingness to serve. There is, I don't know how many of you are spiritually inclined, but one president of the Ramakrishna Mutt by name Swami Ranganathananda, who was one of the most revered monks to have been the president of the Mutt, was asked what the term spirituality meant to him. And he responded by saying, when I shut my eyes, I feel peace within. When I open my eyes, I ask, what can I do for you? So when you say access to justice, really, it has to stem from a deep-seated commitment and a sense of duty to be really effective. We are flooded, courts are flooded with the public interest litigations, and really our challenge there is to sift the wheat from the chaff, to identify genuine concerns, believe in the power of the courts to do good, and stay the course. How the courts stay the course is by sometimes issuing a continuing mandamus, started from Godavarman Thirumalpad's case, where we issue a mandamus and hold on to the mandamus to ensure that whatever is the good that we had intended leads to fruition and does not get somewhere interrupted and lost along the way. That's the first point. The second point is alternate dispute resolution mechanisms, justice even before you reach the courtrooms. For many reasons, mediation today is taking center stage as an alternate dispute resolution mechanism in preference to arbitration. We are all familiar with how mediation works. I think it's a mandatory subject. ADR is a mandatory subject, if I'm not mistaken. And it's a process where the parties in conflict identify an impartial and a neutral person who will help them negotiate the conflict and arrive at a conclusion. In my experience, however, mediation is not an easy concept to sell to a society that wants to win always and unconditionally. In mediation, the end result is that both parties get a satisfactory resolution and no one person wins. This calls for a society that is mature enough, that is cultured enough to be more accommodative and generous than what we presently are, and less adversarial and aggressive. We have a mediation center attached to our High Court, which is the first mediation center in the country to have been started. And recently we're administering a drive called Samarasam Seyya Virumbu. For the non-Tamil speakers in the audience, that means prefer non-adversarial methods of litigation, of settlement, rather than adversarial methods. And in this, we are covering all the 38 districts in Tamil Nadu in the hope that persons will see the benefits of mediation, which will, we hope, give a huge fill-up to the access to justice movement itself. ADR, particularly mediation, is not something new to our country, as we are all familiar with Maryada Rama and Birbal and Tenali Rama and our village panchayats, which settle scores of disputes before they reach the court doors. The modern avatar of this is the mandatory pre-litigation mediation under the Commercial Courts Act and the enabling provisions under the Civil Procedure Code, which encourage ADR. We have a lot of material on how this is being addressed internationally and in many courts in the country as well. Unfortunately, for paucity of time, we are not in a position to present it to you. But this is one area which really requires to be exploited and explored if one wants access to justice to be really effective. The third is the use of technology. Now, the silver lining of the COVID pandemic, if at all, one could say that it had a silver lining, was that it propelled us overnight to seek modern methods of justice resolution. It fast-tracked the use of technology in courts. Overnight, courts had to frame video conferencing rules. We had to get the infrastructure for the cameras, the screens. We had to train our judges on how do you conduct courts online, and all this to enable virtual hearings. This was a huge success despite the concerns about the patchy connectivity, etc. And today there's really no going back on that. I want to share an incident that gave us a great deal of comfort. During the COVID times, life had to go on, and we had to make some recruitments for our state judicial academy. So we had about 75 candidates who we had to interview. And many of those candidates, we gave them the option of either coming before us or logging on and being interviewed. And one of those candidates was from a small village in Kanyakumari, the very end of the country. And on that day, the weather happened to be inclement, and the child did not have connectivity at all. But she said, "Please bear with me, I will find a spot in my house where I am able to get data." And we were so happy to see her tenacity. So we stayed with her online. She took us literally on a tour of her house, and she found a spot where the internet connectivity was good, and we were able to interview her online. That day really came home to us, the power of technology and the power of using technology to access justice. Today, we also have online dispute resolution platforms that allow parties to resolve conflicts without having to step into a courtroom. There are also offenses like traffic offenses where you've got virtual courts, where you don't have to go to the court at all. You receive a summons and you have a link which takes you to a court, a virtual court, where you're able to settle the dispute without having to access the adversarial system of litigation. That's the second. The third, use of technology. And now coming to the last, the strengthening of institutions that are the guardians of democracy. And this starts with you and me. And when I say you and me, this is irrespective of whether one is a judge, when one is a lawyer, when one is a media person, or whether you are a student. All that matters is that we are citizens, equally interested, equally committed, equally passionate about taking justice to the doorstep of the man who doesn't have that access today. That's all it takes. The Constitution promises, apart from liberty, equality, and fraternity, an undefined, ephemeral, transient treasure, and that is justice. The term is not defined, and rightly so, because one can hardly define a term such as justice exhaustively. It assumes different colors and contours depending on the situation. In our state legal aid centers, we try to find creative ways of taking justice to the people. In Idukki, a small village in Kerala, they have got a mobile van, and that van goes to different locations every week. And likewise, we have got centers where in remote, far-flung areas, for instance in Yerkad, where a person from a village or a person who's part of a tribal community can go there, get advice on how do you file a case, what are the options available, and there are people there to help, to assist them in the process as well. It is imperative that to take justice to the doorsteps of people, pillars of democracy must work in tandem. Courts must be independent, legislatures must be accountable, and media must be free. There is a call to action today, and that is the strengthening of institutions, which requires both systemic reforms and cultural shifts. If only there was a will among the people, among stakeholders, among citizens, every single day, this can be achieved. This participation can take many forms, like filing an RTI if you want to uncover corruption, attending a public hearing on environmental issues, or simply holding leaders accountable through informed debate. The responsibility to ensure that everyone has access to justice rests with each one of us. Justice Mittal said in her talk that she gave you an instance about the docket explosion. And in one way by which students can help justice being accessed by everyone is to reduce the time taken for each case to be heard. And that means asking for fewer adjournments. That means being better prepared with your cases and having a time fixed for each case so that every matter takes only that long and no more. More litigants can be heard and justice can then be accessed by a larger group of persons. Justice is really the oxygen that sustains democracy. It's present in every classroom where a child learns without fear of discrimination, in every workplace where women are treated fairly, in every village where farmers have access to fair markets, in every home, I don't mean a senior citizen's home, I mean our own homes, where a senior citizen would have access to living a life with dignity. All this requires collective effort, not just from democratic institutions and from governments, but from civil society, businesses, and individuals like you and me. I must commend NDTV for having this function in Madras. This is the land of Manunidhi Choran, as all of you would know. Manunidhi Choran was a king who brought justice. The legend has it that a cow goes to him asking for justice because the king's son runs over the calf with his chariot. So she goes and rings the bell there to call the attention of the king and say, I need justice. And the king gives the cow justice by subjecting his son to the same fate that the calf had suffered. Of course, there is divine intervention thereafter, and both the calf and the son are brought back to life. But the location is thus a good location of choice. I will end by saying that you would all be familiar with the phrase qui vive. It's a French term which means who goes there or who lives. And in the context of law, it was used first in V.G. Rao's case by Justice Patanjali Shastri, who says that he calls the Supreme Court a sentinel of qui vive, which essentially means that the Supreme Court has to be on high alert at all time to ensure that justice is not denied to any person at all. I would think that that is something that is to apply to each one of us. We should all be on qui vive mode all the time to ensure that if we find that justice is being denied at any juncture to any person, we raise a voice, we raise a call, and ensure that every individual feels seen, heard, and valued. Thank you very much.
To stay with us, and we're welcoming back on stage Dr. P. Satyanarayanan, Pro-Chancellor Academics, to felicitate Honorable Justice Dr. Anita Sumant of the Madras High Court. And thank you for the message, ma'am. Reiterating what we have heard, not at all, what we have heard actually through the conversations today, which is that all of us have a role to play in taking justice to the doorsteps of people across this country. We now move to our next fireside chat, Law in the Age of Disruption, AI, ESG, and Digital Transformation. For this discussion, joining us via a live link from Mumbai is Cyril Shroff, Managing Partner, Cyril Amarchand Mangaldas. He will be in conversation with NDTV's T.M. Veeraraghav. A round of applause, ladies and gentlemen.
Thank you, sir. Thank you, Mr. Shroff, for joining us. I think it's apt that you're joining us online for this conversation because the topic is about AI, digital transformation, and how it's impacting the legal frameworks. I just hope it's the real Cyril Shroff who's joining us and it's not an impersonator who's coming online. But let me begin with a broad question, Mr. Shroff. You've set up the Cyril Shroff Center for AI, Law and Regulation. What are the three key challenges that the Indian judicial system and legal framework faces from the pace of technological transformation?
Thank you, and pleasure to participate in this. I wish I could have been there in person, but I can see that the arrangements are quite elaborate and exciting. So delighted to participate in this, and thank you for having me. So let me go back to part of the rationale for why I set up the AI Center at Jindal and what I see as some of the key challenges. There are many, and there are many opportunities as well, but three key challenges. So firstly, I think AI and the law are moving at very different pace from each other, and rhythm as well. Currently, just by the very nature of the beast, technology is ahead and the law is a bit lagging. The law tends to move in a linear way, whereas technology kind of moves in a more exponential way in multiple directions. And that's what we are seeing, which is why there is always the struggle in terms of the law keeping up with how technology moves. So that's point number one. Second, I think one of the challenges and which kind of emphasizes the need for protection against certain inherent flaws that technology has. For example, we know about the risk of hallucination in AI, and particularly the large language models. There is bias. There are safety issues. We've seen in the last few days some cases where people sort of developed almost like a relationship with a chatbot, and some young minds committed suicide. Who is responsible for this? This is a safety issue as well. And of course, the law will have to find a way of dealing with it. And the third big challenge that I see is capacity and capability. Capacity and capability in government and the policy environment, capacity and capability in the judiciary and in the legal profession, and capacity in capability in the legal profession as well. And part of the motivation for setting up the center was to assist, make at least a small effort to assist in this capacity problem. So these are the three major challenges I see: different pace, protection against inherent flaws, and the capacity and capability problem.
So you run one of the largest all-service law firm in India. What's the impact AI has had, and if you can give us some kind of an anecdotal story on A, on your firm and how it operates, and B, on yourself as a lawyer?
Oh, thank you for that. And I think it's early days for seeing what impact AI will have on the legal profession and on law firms, but we've made a beginning. Just a quick update on our firm, since you asked me about the firm. So we would be amongst the largest. We have over 1,200 lawyers across the country. And we have, apart from offices in India, we have offices overseas as well. And being a more full-service firm with both corporate as well as litigation work, technology is a big tool that is available to us. But as I said, it's early days. We have been using some form of artificial intelligence since the last 7 years, machine learning, and more recently with the arrival of large language models, we now have a technology partnership with one of the leading global AI service providers. Every lawyer and every business service professional in the firm has access to this. We have given people two options. They can use either or both, including some of the latest products that are available from the likes of, say, Microsoft and others. Now, this is currently intended as an efficiency tool or as essentially an enhancer of their capabilities. It is not in any way meant to substitute the core aspect of lawyering. This finally, whatever is produced by AI or technology has to go through human oversight. And ultimately, it's the firm and the human beings who take responsibility for the work product. But it is very useful. It is useful not only on client service, it is useful on talent management, it is useful just on the efficiencies of running a large organization. It is having, to answer your second question, it is already having an impact on not only efficiency but also on the commercial model of the firm. For example, there has been an increasing shift towards fixed fees rather than the classical hourly rate model. Or there is a movement beginning on what's called a subscription model of how services are provided. The speed of our responses has gone up.
Okay.
And to give you a recent example, we used it in, we use it all the time, but we used it in an interesting litigation. Now, in this litigation, which has been going on for 6 or 7 years, the other side changed 5 lawyers in the meanwhile, and every time a new lawyer came, they came up with a new argument.
Okay.
So what we did was, with the use of AI, we were able to show that every time a lawyer changed, they changed their case. And we were able to show it to the judge. And that was actually quite devastating. Now, manually, if we had done it, which we could have, it would have taken days and days. This was done in a matter of minutes as well. So that was a very recent, and we won the case because of, for many reasons, but because of one of this was just that it prepares you better and it gives you better tools. So this is a quick recent anecdote just 2 months ago on how we used it.
Interesting that very interesting that you point out to how it's practically implementing your law firm. I want to bring to the larger context of the Indian judicial system. One of the key aspects, and it's been time and time again emphasized since morning, is the large backlog of cases, the delay in delivering of justice. How do you believe we can embrace technology to deliver justice fast, but without ensuring that there is no miscarriage of justice? Sometimes when we hasten up and embrace technology, it can have dire consequences.
No, great question. And this is a debate that is going on very fiercely across the world. There are several leading jurists and commentators, like one of them, like Richard Susskind and others, who are debating this extensively. This is a very live problem, and there is no final answer to this as yet. But amongst the thoughts for how we could use technology, AI, and sort of new age processes for reducing judicial delays, and India has a chronic problem on these, is to use technology for many things. One of which, for example, in managing the caseload, scheduling of hearings, analysis of basic factual materials that are placed before which are filed as well. For example, pleadings analysis. It's not just the lawyers who are using this, but I think even the judges have started using this, and not just a ChatGPT kind of thing, but more specialized software as well. And there's a difference between how you handle small routine cases like motor accident or 138 cases, and that genre of fairly repeatable small value cases is one genre, but even on large cases. So I do think that we will see technology being used there as well. There is something called assisted adjudication as well, where the technology can be used for the justice process. But one thing which is very clear, and I think it's a constitutional issue, is that at the end of the day, as our constitution stands currently, we have a right to human decision. You can't have machines handing out sentences or passing judgment. So technology takes you up to the point, but the final bit has to be human as well. So which is fine. I think it's still, you can still end up saving a lot of time. There will need to be a human in the loop, because there could be unconscious or conscious biases. There could be issues around admissibility of AI evidence. You also have the hallucination problem as well. So all of that taken into consideration, I would summarize it as technology and AI will definitely help in managing judicial delays and just the time taken to resolve cases, but it is not perfect as yet, and it will take a very long time before even this improves. But it is certainly helpful. The direction of travel is clear, and I think it's going to make a difference.
Right, important point that you make there. I want to shift conversation to ESG, which is perhaps extremely important for the students sitting down here who plan to take up corporate law in the future. How do you think it's really reshaping the role of a corporate lawyer? I mean, what would be, if I can just go off script a little bit and ask you, what would be your advice to students wanting to take up corporate law today?
You must take up corporate law, and of course, I think the more important thing, and my own career is an example of that, is that you have to be a generalist. I think at least a core part of your career has to be spent on having a lot of horizontal experience in terms of different branches of law before you select a vertical where you go deeper. Now, ESG and everything that it means is actually a horizontal. Because in my view, ESG is not like a sector anymore. That's how it began. Or a practice area. It is more like a vector, which is affecting every practice. It affects corporate practice. It affects disputes. In fact, climate litigation, which would be part of the E, is one of the most prolific areas of litigation across the world as well. So I actually think there are three maha-judicial trends, if I can call it that, in terms of new age disputes, and one of them is climate litigation or ESG litigation. The other is data, and the third is geopolitical. But I'll come to that separately. So ESG, I think, is a very important skill. I don't think there is enough scope yet to be a specialist ESG lawyer, but you need to have an ESG mindset. Through which you can advise clients on all their problems with an ESG perspective at the back of your mind. Now, again, ESG is three separate words. There's environment and climate stuff, then there is social, and then there is the G, which is the governance. And governance, in my view, is the enabler of both the E and the S.
Right.
In India, the G has gone far ahead. I think G has a lot of the conversations that we have today in the public sphere are more about the governance. A lot of the issues and road accidents that we see in corporate India have to do with the governance aspect of it. So governance supports the E and the S, and it is very important because it can derail, for example, a big M&A transaction. Just to give you a very corporate example. So you can have a terrific corporate transaction, great M&A, but if you didn't consult the minority properly, somebody could come after you from the governance perspective and stall your transaction. You could be taken to court. We today also have proxy advisory firms who comment on issues of this nature, and they're very powerful as well. So the E and the S and the G it's a bit like a hovering spirit that covers so many different activities, including the corporate sphere. It's not a separate topic, it is embedded in everything.
And very briefly, what would be the key risks that large or small corporations face in an evolving regulatory framework, A? And also, is this a great opportunity for Indian lawyers and Indian system to scale up to global standards?
So, frankly, I do think that Indian lawyers are already up to global standards. What is missing is some of the infrastructure. On a one-to-one basis, I would bet on an Indian lawyer any day.
Okay.
And there's a reason for that, is that part of our, our education and our training allows you to be a generalist, which I actually now call multi-specialist from day one. You could go into a meeting with a good lawyer, and he's not going to say, oh no, I need to talk to my tax person, I need to talk to my employment person, I need to talk to my X person, Y person. He will at least give you a prima facie answer on the spot. And then he will check with somebody, which would be very rare with an internet. Sort of a good Indian lawyer can do the work of 5 or 6 multi-specialists, at least at the prima facie stage. So we are able to connect the dots. Now, it's an ongoing debate in the world as to what is more important, a generalist or a specialist. And I think the answer is both. But we produce far more generalists in India, and therefore, I think our standards are not lower than anything else. But to answer your first part of your question of what are some of the risks, I think there are many risks, and these are risks in the business world which kind of reverse engineer themselves into the legal profession. First, the first biggest risk today, and for reasons that we read about every day in the papers, is geopolitics. I think geopolitics is not just one of those abstract things which only prime ministers and foreign ministers worry about. I think it is affecting all our lives. It is affecting the lives of big business. It is affecting the life of small firms. It is affecting the life of everyday citizen because it has an impact on costing. It has an impact on availability of services, etc. So this is number one, and this is a big boardroom conversation. The second, I would think in terms of importance, in terms of risk, which a young lawyer like those who are sitting in the room should be familiar with, is the arrival of AI and cyber risk as well. There is a cyber incident taking place almost every minute. Of course, there are systems to protect against it, but you need to be aware of the impact of technology. A third big area which is also again a very more general point, is the regulatory flux. The regulations are changing very fast across the world, even in India as well, whether it is public market regulation like the SEBI rules, or whether it's RBI's rules on foreign investment, or different interpretations of company law, or if you move to environment, different environmental standards, they're constantly changing. So the need for the corporate India needs this advice. For example, on GST, I mean, everything changed just now. And you need the almost instant advice on what does the new GST regime mean, and what does it do to the supply chain model, etc. But coming to, what does a young lawyer need? I think a young lawyer needs to have a mindset of being always current on new developments, particularly if you sort of intend to, concentrate on areas which are impacting the growth of India, Viksit Bharat, etc. I mean, Viksit Bharat is going to happen both because of government and the public sector, as well as the private sector, and both are affected very differently.
Right.
So these are some of the three or four top areas, but I could go on and on.
Right. Thanks, Mr. Shroff. I concede to that point that our lawyers are of global standards. Thanks very much for speaking to us here on NDTV. Unfortunately, we're totally short of time. Of course, there are many, many more questions to ask you, including about the impact of the global system on the Indian frameworks, but perhaps another time. But thanks very much, Mr. Shroff, for joining us here virtually at this conclave.
Thank you for having me, and my best wishes and respects to all the dignitaries who are sitting in the audience. Unfortunately, I'm not there, but I can see some of them in the first row. So my respects to all of them.
Thank you. Thank you very much.
Thank you for that, Cyril Shroff and T.M. Veeraraghav of NDTV. Okay, so while the stage is being set for our next panel discussion, I would like to remind you all that today's event, the SRM Lexposium 2025, is being live streamed on the NDTV 24/7 YouTube channel. So in case you need to leave, and we really hope you don't, but in case you do, you don't have to miss out on any of these fascinating conversations. You can watch them all on YouTube as well. That is the power of technology, and technology is in fact the topic of our next panel discussion. As someone has said, technology is not the future of law, it is the present. As law meets technology, the future of the profession is being reshaped before our very eyes. Our next panel explores how AI, cybersecurity, and digital transformation are revolutionizing legal careers and what today's law students must do to stay ahead. So to all the students here, this is a particularly relevant conversation in a day of very relevant conversations. We'll pause just a moment for the stage to be set before we invite up our guests for today. For this conversation, I would like to invite on stage Ms. Swapna Sundar, Senior Partner, PVS Giridhar Associates, Mr. Jayant Saran, Partner, Deloitte India, Mr. Arun Balaji A, Partner, EY Forensic and Integrity Services, and Dr. Vinay, Pro Vice Chancellor, SRM Institute of Science and Technology. Moderating this discussion is my colleague, Suchetna Ray. Please put your hands together for all of them, ladies and gentlemen.
It's been a great day with great invigorating conversations, and as we come to the end of this program, we will deal with what is most important to all the students who are here watching this since early morning. It is about your profession and how it is shaping up for tomorrow. The rise of artificial intelligence, or AI, and the growing complexity of cybersecurity challenges are reshaping the practice of law. Tomorrow's legal professionals must be equipped to operate at the intersection of law, technology, and ethics. And this panel brings together experts from legal practice, forensic investigation, consulting, and academia to explore exactly what is happening and what is transforming legal work. I have with me Swapna Sundar, Jayant Saran, Arun Balaji A, and Dr. Vinay in this panel. And as they say, ladies first, so I'll begin this panel with a question to ma'am, to you. My first question is, how do you see AI tools such as predictive analytics or even contract automation transforming the role of practicing lawyers in India?
Thank you, Sujitna. That's an interesting question. And in fact, when the topic came out, I was thinking about it like this. So in the medical field, we have medicine professionals who provide consultation, then you have surgeons, and you have a whole industry of diagnosticians. So today, nobody dares to give you an opinion without saying, please go and get this battery of tests done. Right. I actually see an evolving trend where there will be a framework where a new career which includes or integrates law and technology will evolve, and we will become increasingly dependent on them for our decisions.
Of course. I'll go to Jayant after that. From a forensic and compliance standpoint, how are AI and advanced data analytics changing the way investigations are conducted?
So, anecdotally, and this is again for a lot of the young minds out here.
Right.
18 years ago, when I started with forensic technology as a space, we had to literally go to people and ask them why they weren't using technology in their investigations. Cut to 18, 19 years later, I can't do a forensic investigation without the use of technology. Right? So that's how evolution happens, and that's how it's going to happen for everyone here in their lifetimes. As far as an investigation itself goes, if I look at transactional data, it is all sitting in digital forms.
Right.
If I look at the evidence trail that gets created through the discovery process, which is through emails or documents, that is largely sitting in digital formats. And of course, over the last couple of years, we've all tried out, tested out, moving away from traditional keyword-based reviews, which is what used to happen, to now using generative AI to be able to summarize a whole set of documents, things that could be done, or that would take us perhaps a year and a half to go through in a large matter, now can be done in a matter of 6 to 8 weeks.
Right. Since you mentioned generative AI, before I go to Arun Balaji, I'll first like to go to Professor Vinay. What has been the impact of Gen AI, specifically, say, tools like ChatGPT, DeepSeek, to students and the way they absorb curriculum, the way they absorb the classes, the courses that you have? Because I was just discussing with Swapna here, and she was mentioning how large judgments could now be summarized by just putting them on generative AI tools and just taking the crux out of it. Does it take away from reading?
Yeah.
I think, the technology that we have right now, the AI platforms that we have, will add a lot of ease to the legal profession, because it can do a lot of things that essentially require, a sort of a researching type of a framework. So AI is quite capable of actually digesting a lot of data and putting it in a very cogent way. So therefore, it's quite simple to actually use an AI framework to actually understand the research of a case. And therefore, every lawyer will have to basically equip themselves with, with these new technologies, because it has a huge utility. But the essential this thing is about how do we understand what type of risks that these platforms will pose later. That's the question. I'm sure you'll
That's
get to that.
That's exactly what I was getting at, yes.
Yeah. So the point is, the AI as a general framework is actually currently uses technologies like, autoregressive models and things like that. And then now a lot of neural networks things, people are coming up with technologies which involve neural networks and things like that. Now, the point is, AI as a platform itself is evolving. Nobody knows exactly how is it actually going to finally shape. Nobody knows it. As of now, it uses certain technologies, it has limitations, but then when it actually evolves as a true intelligent and self-knowing kind of a platform, then it will definitely pose a risk. So that's why legal professionals are not just going to be legal professionals, but they're supposed to be equally equipped with these technologies. Otherwise, you'll not be able to make meaning. That's the whole...
Absolutely. I have more questions on that, but before I come to that, I'll come to Arun Balaji. How in your work on, say, integrity and compliance, how do you see AI creating the biggest opportunities and risks for legal as well as the regulatory systems?
So I think the opportunities part has been covered well. I will only add a couple of them which is not covered. People feel that this is going to take away jobs, but that's not the case, because these are going to create jobs, because this is doing what was never done before.
Right.
So often companies will have thousands of contracts, never read, never looked for obligations. So it's only creating jobs, so people should not have that fear that AI is going to take away jobs. So the opportunity itself is going to get created for more employment. Second opportunity is the speed at which we can do. Like Jayant was mentioning on how you can sift documents, which was taken months, can be done in about weeks. And more importantly, like how Sapna is saying, also bring in predictive part of it, to say how can you predict and reduce the focus in which otherwise we would have spent years together before we could go to a court or even go to an arbitration. So when all these opportunities are there, the risk is like how Cyril was mentioning a little while ago on bias. I call it, in our parlance, we call it as an operator bias, because the prompt I'm giving and what I'm asking is what it will give back. So typical word to look out is an operator bias. So the more I am biased into what I need to know, that's what it is going to tell me. So it's important to be neutral, use the right prompt so that you get the right results, so that you are able to use that. And the other part of the risk is, if there is no human in the loop, we are going to head for a disaster in terms of using that. So it's important. Today's accuracy ranges between 40 to 70%.
Right.
The best is 70% what people have achieved. So it's important to keep assessing that accuracy before it's best used in judgments and as evidence.
Right. I'll come to you, Swapna. Let's talk a little bit more about cybersecurity. With breaches, cybersecurity breaches, that is increasingly leading to litigation. How do you think should lawyers of tomorrow, adapt their practice to handle these new age disputes?
Thank you, Suchetna. I think I would like to look at it from two different perspectives. One is data security and cybersecurity for law firms.
Right.
Because lawyers do hold a lot of incriminating evidence in their computers and laptops and systems. And I think we lawyers are, in India at least, a little less worried about cybersecurity than some of the corporates that we serve.
Okay.
That stated, I think some of the CERT UK, I think, actually said 65% of law firms have been at risk or have been attacked.
Okay.
So this is something that we lawyers have to think about in our practice. We are today highly, or maybe we are slowly moving towards e-documentation, but until today we still have a lot of things on paper, and to that extent we are safe. At the other end, I think my colleagues will be better able to answer, but I think we have to work with cybersecurity specialists and forensic experts. Among the different things that will come out, like legal, techno-legal protection of data and so on, I think one thing that really has made a difference to these litigations in my practice is rapid response. And I think it's very, very important to have our cyber forensics team and our IT infrastructure team and our audit and security response team on speed dial. Because the more time we waste in stopping the attack, that much is the damage that our corporate clients will face.
The turnaround time is really low.
Yes. Rapid response is something that we have to
Jayant,
enforce.
I'll come to you. I'll ask my question, then allow you to respond as well. My question to you is, what are the key cybersecurity risks that business are facing today, and how do they translate into legal liabilities?
That's an extremely broad set of exposures that we are talking about.
We are the generalists, as Cyril was just trying to say.
But I'm going to try and sort of narrow this down a bit, if I may. I think the biggest issue, and much like what you said, is the data, right? So whether I have a ransomware attack which shuts down systems, at the base of it all, I still have data exfiltration happening.
Right.
If I have what is called a business email compromise, spoofing attacks, there's still data that's at risk. So the biggest risk is going to be data. And the biggest dispute arises out of that too.
Yes.
Right? Now, if I look at, let's say, a scenario where, I'm a vendor and, I've got an email, she's, or maybe you are the primary company, and you get an email saying my bank details have changed, can you transfer money into this account or the other, right? You transfer money thinking you're transferring it to me, right? But I haven't got the money. So I'm going to come back to you and say, look, I haven't got my money, I need to be paid. You're going to say, look, I've paid money. So there's a dispute that comes out of that. Right? So there is a legal element there. If I look at any data breach that happens on its own, now with the DPDPA in place, there are a lot of obligations to report and, right down to the individuals who are breached. Right? So I have to, and I give this example to my clients, and I'm going to give it to this audience. If I'm, let's say, if I'm a bank and I'm breached, I need to tell certain, I need to tell the RBI, I need to go to a cyber police station, I need to tell my cyber liability insurer, and if I'm a listed bank, I need to tell SEBI.
Right.
Okay? And now the Data Protection Authority coming in, it's going to be that, right? Now, all of this requires a concerted effort with an eye on regulations, which is where the legal element comes in as to how do you sort of respond to each one of these entities. But there's also a technical part as to the fact-finding, root cause, how did it happen, where did it happen from, what was impacted, what is the data breached. All of that needs to be established by, let's say, a cyber forensics professional or by an investigative agency. So the ecosystem itself, much like what she said, is now turning into, it cannot be one person who will address an issue. It will be a whole ecosystem, much like what they say about you need a village to raise a child.
Right.
You need an ecosystem to be able to address issues that happen. Sorry, I'm going to keep quiet now.
Right. I'll go to Arun Balaji. A large part of cybersecurity incidents are often cross-border. So how should legal professionals prepare for multi-jurisdictional challenges in investigation?
This adds back to some of the comments made by the Lordship before this. How we know about other jurisdiction beyond India is very important, because often the breach has data which is of different countries. We need to know those regulations before we can respond, before we can file whatever is the requirement as per those countries. So along with studying law, it's important also to keep a tab as to what we need to know about minimum regulations about other jurisdictions with respect to personal information, health information. It's very important because most of the cyber attackers are looking at these important information. So you need not know every aspect of law of every country, but at least the attackers are mostly focused on the personal information, health information, so banking information. So those regulations of the key countries should also be part of the curriculum, should be part of available content for the professionals so that they are going to be more relevant. Like Cyril was mentioning a little while ago, like, yeah, we are there at par with the global, but how we are going to be along with them will be how the curriculum changes and how the exposure changes to the professionals.
I'll come to Professor Vinay, and I'll take up from the point that you were making in your last answer, which is the lawyers of tomorrow and will have to operate on the intersection of law, technology, and ethics. Now, what we understand from our other panelists is that this entire terrain of AI, cybersecurity, technology itself is changing at a maniacal pace. So how does curriculum and students keep pace?
So fundamentally, if there's anything smart, it's got to be vulnerable. And invariably, it's going to be vulnerable. And there is a marketplace for all these vulnerabilities, in the sense that if you have created a smart technology that is going to solve some problems, and if it is really solving some problems, some people are really eyeing at that because it's going to create a marketplace for them, and then therefore the data that is extracted from these smart systems I'll be able to use it for personal gain. And that's continuously happening, irrespective of whether it is AI or any other technology previously. Now, the basic, the challenge that we have when we have to actually deal with the curriculum change and then actually equipping students to be, experts of both worlds. Now, that's not such an easy thing, in the sense that typically we have law curriculum where we are training people to be, really good legal professionals, irrespective of what is the context. Now we have a sort of a totally different skill set that needs to be added.
Yeah.
Now, to what extent do we add? What are those technologies? How deep are you going to go? Because, the depth is everything about understanding the problem. If I don't understand the algorithm, I'll not understand the justice.
Yes.
Whether this algorithm is going to make the justice or not. So that's the challenge that we have. And then we are actually grappling with it in the sense that, a lot of workshops we do, a lot of microcredits we are trying to get in so that people have a fairly good understanding about what type of changes are expected in the future for the legal professionals. But it's not a simple thing.
Right. So you said algorithm. So are you trying to scare your students by saying that it's not just enough to study law? They need to perhaps learn coding first, something else tomorrow, and something even more complicated the next day?
Yeah, absolutely. So the technology, see, I was telling you, the large language models are actually transforming quite rapidly.
Right.
So, we don't know where is this trajectory going in the first place.
Right.
Okay, so in other words, let's say I train my students with a certain technology, and 6 months hence from now, the technology is completely different.
Yes.
Within the AI ecosystem, the technology is getting disrupted. So in other words, it's quite a difficult challenge for universities to actually implement these things. But we're catching up in the sense that whatever that is currently relevant, we're trying to see it, but nobody is able to predict it, right? So people are saying that the huge disruption is going to happen within 2 years.
Right.
Whether it's 2 years, 5 years, nobody knows actually. That's the...
Right. We're speaking of seismic shifts brought about by AI and cybersecurity challenges. We've scared the students enough. But let me wrap up with one question to each of you. Where are the opportunities? We are talking to students who will very soon go out into the world looking for jobs. So I'll come to Arun Balaji first. With the importance of GCCs in India, do you think that there will be enough jobs in legal services perhaps flowing into India?
Yeah. As the Lordship mentioned that COVID pushed technology. Until that time, GCCs were always focused on IT, HR, accounting, finance. But post that, actually, most of the GCCs are evaluating how do they bring in legal into the whole function. So today we have about 1,500 GCCs in India. It's going to become 3,000 in about 5 years. And it's an ecosystem and economy by itself.
Right.
And there is going to be large opportunities of legal operations moving here. So there is one more new destination which will open for all the lawyers to practice law and learn the global law as part of the corporate setup. And then that will have a rubbing effect on how the law is practiced in real courts as well. So the GCC is going to be a big opportunity for lawyers. Thousands of lawyers are going to be in demand with the way GCCs are looking to build legal operations in-house as part of the global captives.
Right, I'll come to Swapna. You know, when we talk about technology, it's not just about the LLMs or the new phases that are coming up. It's also about the countries who are coming up with the patents for this, and therefore most of these softwares and their use also have laws which are foreign. Where does it put the students or the lawyers of tomorrow who are going to deal with these?
Thank you. As a law teacher, I would like to also say this, that for students, there is no out of syllabus when you're a lawyer. You cannot actually say that this never was taught to us. You just keep learning. The second thing that I always tell my students is the law cannot be taught, but it can be learned. And it should be learned. And this is exactly what Abraham Lincoln said as well, that you have to pick up a book and you have to read till you get the fundamentals of it. That said, our devices are made by Samsung or Apple, either in India or elsewhere, but it's a Korean technology, Korean company, or they're made by Chinese manufacturers like Foxconn and Sriperumbudur. And our AI is manufactured or deployed from countries like USA or Germany or China even, and now we're going to definitely have many more countries jumping into the bandwagon. We don't yet have control over which country is deploying what technology and what are the devices we are using. And I think that it does leave us a little bit in a quagmire. For instance, when I upload certain data and get a summary of the, say, the testimony that I received or the instructions that I received from my client, and I upload it and say, give me a summary, I'm going to upload it to ChatGPT or any of the large language models that's going to be used as training data, that's going to be used or sold as further data onwards. Does it require the consent of my client? And what is the security that is there around it, even if it's a subscribed service? So while it is there and it's a strong decision-making model and it can be used to help us to predict and analyze, I don't think that we should take it so lightly. I don't think students should be so completely dependent on all these models. I still think we should go back to the legislations, read them, and the judgments in full.
While Sapna is trying to open up a new topic of discussion here, and we are running out of time, I'll come to you, Jayant, with my last question, the same question, that in this entire landscape of cybersecurity, forensics, which is extremely dynamic in nature, how should the lawyers of tomorrow prepare themselves to put them in great stead?
See, much like Swapna said, there's nothing out of syllabus, right? And, as lawyers, I think, firstly, there's no substitute for actual reading. The generative AI, and we're already moving away from generative AI to agentic AI.
Right.
So we're already on a journey which is going to move away from, the AI that we've all read about for the last year, right? Which is going to be autonomous AI that can take decisions.
Right.
Right? So, as students, I think you would need to be aware of what's the development, how to use it. But I think the knowledge will still need to be acquired. And there's nothing out of syllabus. Even if you're looking for a career in forensics, you will need to know regulations.
Right.
You will need to know perhaps, NAFRA rules. You'll need to know, you will need to know SEBI's LODR. You would need to know, all of that. You would need to know, and there's no substitute for that, depending on the area of practice you're going into. So that's one part. The other bit is going to be that please remember that you will need to learn how to harness technology, because it is a great enabler. It's not a replacement, at least not yet. But if you at least start learning how to harness it, as it evolves, so do you. So I'll stop with that.
Thank you very much. We've completely run out of time, but thank you very much to each one of you for taking the time out and joining us today. And for the students, as you heard, read, read, and read. On that note, thank you.
Thank you all. Do stay with us on stage. That was a fascinating conversation on the seismic shifts brought by AI and cybersecurity challenges. I now request Dr. P. Satyanarayanan to come on stage and felicitate our wonderful as Lexposium 2025 reaches a crescendo with two more very powerful speakers, we will wait before we invite our next speaker up for the stage to be cleared and set for our next keynote address. Do bear with us for a moment more. And while we wait for the stage to be set, could I please request the students in the audience to perhaps come forward and occupy the front rows. As I was saying in the morning, backbenchers are the one who attract maximum attention. So it's far more safe if you're sitting in the front of the classroom or auditorium. That was a joke. But, okay. For our next keynote address, ladies and gentlemen, it is my privilege to welcome Honorable Justice Retired Ajay Rastogi, former Judge of the Supreme Court of India, to deliver his address on labour justice in a changing India, balancing rights and economic growth.
Good evening to all of you who are present. And I first congratulate to all the managing committee of SRM School of Law, and particularly Mr. Shri Narayan, who is sitting since morning, and the media partners NDTV. In holding this Lexposium 2025, we have heard symposium. Symposium, to my understanding, is when the experts sit together and discuss on a particular subject. But when you find this exposium, to my understanding, is when the legal luminaries sit together and discuss on the subject of law. So that becomes the exposium. And this word chosen by the SRM Institute here, I must congratulate. A new phrase has been developed for this purpose. The subject which has been given to me is the labour justice in the changing India, balancing rights and economic growth. I first asked all the students who are present that since morning you are listening to the word justice. Justice has so many phrases. Justice is the word which you find in our preamble. And we talk about justice in our preamble. It says about social, it says about political, it says about economical. Rest, you will not find this justice in the Constitution. To my understanding of our Constitution, and particularly the preamble, which is the heart and soul of this living document, when we talk about social justice, it's a equality amongst the society. All must be equal. When we talk about economical justice, a disparity of economy among the citizens must have to be rescheduled and brought at par. When we talk about political justice, this is only for the purpose to see that every citizen has a right to cast vote and to strengthen the political system of this country under the Constitution. So these are the phases which you have learned since morning about justice as such. In a common parlance, you must have heard this justice somewhere and in so many places. We say justice has been done to this man because what is due has been given. To whom something is denied, to which he is legitimately entitled for, we call it justice has been delivered. When the child asks to his parents that I have done my homework and let me permit to go and play, and the parents grant him permission, that is justice to the child. So my request is that justice is of a very wide repertoire, which can be used in terminology in various sense and in various contexts. And when we come to the term labor justice, which is a subject given to me, labor justice is to be correct with the economy. I don't know whether in your law schools you have read the labor laws. There was a time when there was almost 20 plus labor laws. Whether it is a Minimum Wages Act, Payment of Wages Act, there was an industrial dispute, which is a heart of the whole industrial law. And completely the Inspector Raj was there in controlling the labor laws. Good of this government, they have codified the labor laws. They have summarized them. They have put those labor laws into order and call a labor regulation code, which regulates the labor provisions all over the spectrum. This is something about labor and the economy reforms in the country. Since morning, I'm also hearing here, you are asking about what is the mission of a law graduate after completing law. Somebody says everybody has a mission in life, and I think we must give that liberty to each of them to fulfill it. And my endeavor is never to come into profession. My endeavor always is do wherever you can serve, where you can fulfill your dreams of life. But if somebody asks me to request, I will always request come in profession. Join the legal profession. It has a sky, you enter the sky in this profession, where it is not possible in other spectrum where you serve as a legal luminary. And who can be the better lawyer? My brother Justice Lalit is here. You can't find a better lawyer than him, who has served the society from all spectrums. One of the prominent lawyers in the Supreme Court came on the bench, served the institution to the best. And he is the one who will always remember by the persons who have served, who have been with him and associated with him, and I am one of them. I got this opportunity to share the bench with him. I have the opportunity to hear him as a lawyer. I have an opportunity to sit at all stages in committees. So there can't be a better luminary like him. And if he can be a role model for the students who are present, sky is the limit for all of you. So please, take note of the tips which my brother Justice Lalit is going to give to all of you and follow them. And giving that inspiration will certainly take care of your future as a law graduate. Somebody asked me a question once. Who can be a good lawyer? It's something a very difficult question. Charles has said he is no lawyer who cannot take two sides. And I'll give you a small illustration of it. There was a lawyer engaged by the respondents to address the court. But the lawyer has to know what are the facts of the case. The matter was argued on his behalf, first putting the petitioner's side. Then somebody told him that, sir, you have been a lawyer for the respondent, don't argue for the petitioner here. Then he realized that I am on the different path. He switched over and said, sir, this is the fact which the petitioner was supposed to put to you. Now I am putting my submission to your lawsuit consideration. That's the way the law is being developed. It's the way the lawyers are being developed, the way the vision is being developed. The question once put to me, and I put to this house, every people say that we must respect law. There can't be two opinions about it. If we see that the law is to be respected, we must first respect law. We have to respect first. And if we respect the law, our desire to respect the law will certainly be fulfilled. That is the way by which the system works in. Somebody asked me why you become a lawyer. I said one thing. To my understanding, law is the one which is the most healing profession. If you join medicine, it heals your body. Urge heals the soul. But law heals the society rifts. The societal rifts are such which are creating a lot of problem amongst members, among citizens, amongst neighbors, among family members. So law heals the societal rift. If that mission is to be achieved, the only profession available to you is to join as a lawyer. Someone put me a question also, and I remind here that what experience one should share to become a good lawyer. I said you must be compassionate, you must be a human being. You must know the ground realities, which I don't think AI is going to give you. And one thing more which you have to follow is, you must know your negative points. And your negative points, the day you introspect and find out, that will be your strength in building your future. This is one way by which we learn and we progress in our life. Since morning, I find that delay in justice is one topic which has been umpteen number of times being questioned, and the data is made available to the House is about pendency of cases, non-filling of the vacancies, not availability of infrastructure, quality of appointments. These are the broad facts which have been placed for consideration of this House. I first admit that the long pendency in judicial courts is very disturbing. The faith of the common man is certainly being shaken. The time has come when all the stakeholders must sit together have a deliberation, prepare a roadmap, and that must be implemented in the coming 10 years down the line. Unless that white paper is prepared, nothing will happen. And time has come, any delay will certainly deny justice as the slogan comes forward. If I just give you a data here, we have almost 5 crore plus matters pending in judicial courts. 76,000 something in the Supreme Court, and almost 6 billion matters in the trial court. I always say one thing. Whenever the discussions take place about pendency, we always discuss about the pendency in the High Court and the Supreme Court. But nobody discusses about the pendency, how this pendency can be catered with in the trial court, where the grassroots level comes forward, the man at the bottom in queue knock the doors, who cannot approach High Court or the Supreme Court. So the time has come when we must find out the ways. So far as appointments, the judicial officers is concerned, this has a process of selection, a written examination followed with the interview, like the commission, and thereafter the appointments are made. And after the judgment of the Supreme Court, selections are made by the high courts, almost all over the country. And still, in every high court, almost 30% plus vacancies are lying vacant. You can't hold the collegium of the High Court or the collegium of the Supreme Court responsible. Responsibility lies within the administration of the High Court. And nobody prevents them. Neither the government come forward, nor the High Court, the Supreme Court, or any other collegium. But still, the vacancies are available. So from this platform, I would like to request that every High Court must endeavor to see that all available existing vacancies in their district courts must be fulfilled and complied with at the earliest. And that is only possible when we have a cyclic method of recruitment. Every year we hold selections. The best talent in the market is available to you. A fresh law graduates come forward, although now I think there is a judgment of the Supreme Court putting a rider of 3 years of practice. I have my reservation for that. Anyhow, if one there is judicial view expressed, I can't say more. But my view is, you have to strengthen your academies. You have to nurture the new graduates who are selected. You have to provide them a feedback that what is expected from you by the society, by the judicial system, and you have to create your aura so that you can serve the society. 3 years working, God knows how it will work out. Earlier also this schedule was there, but no positive results ever came forward. If we examine it further, something was said about collegium also in the matter of selection. My request is, my brother Justice Lalit head the collegium. I was a member of the collegium here. Somebody said that the person selected is not as good as the people expect from. I put a question to myself. What is the degree of one's perception to know who is better and who is not? It's very relative. In the collegium, we take a decision after a thorough deliberation, a thorough discussion, the feedback, the track record, the working reports of a lawyer who have worked and served almost 20 years plus. So my request is, there can't be a better mechanism, and still, there's nothing wrong to make it more better than what is being today. When we talk about labor justice, as we are concerned, in the instant topic given to me, which certainly the students I don't know whether the students are aware of these labor laws as such, but I can only share few tips to give my reference to it. And when we talk about labor justice, it only refers to ensuring fairness, dignity, and protection for workers. And that will be possible only when there is a fair wages, reasonable working hours, job security, safe working conditions, and freedom of association, and access to legal remedies for exploitation of unfair dismissal. If you go back to the days when there was a labor unions, but I think all labor unions have gone. Labor unions were very strong. I can tell you of bank labor unions. They were always coming forward to protect the rights of their members or the employees. And they have a bargaining position with the employer as well. But those labor unions, by passage of time, has lost their own existence. And when we compare the labor justice with the economy growth, which to my understanding is to some extent very relevant for the subject, because 39 crore people out of 49 crore in an informal sector are working, and there is no protection to them. And when you talk about informal sector, that is called vendors, that's called small businessmen people, that's called about domestic servants which are working at your residence. Now 39 crore almost informal workers are not being regulated by any mechanism of law. The wages may not apply to them. There is no mechanism, there is no forum where the informal sector can complain to any agency under the law for better of their rights and to seek legal remedies. Earlier you will find under the industrial dispute, the term was layoff, lockout, closure, and retrenchment. If you have gone through these terms of the labor laws, I don't find in the last 10, 15 years these kind of disputes ever came. Earlier, without permission of the government, you cannot lay off the factory. You cannot lock down the factory. The rights of the laborers, to some extent, have been taken away by clubbing all these courts, and justice to the labor has, to some extent, with my experience, has ignored. And if that is being ignored, what should be done? They need safe working conditions. It is ignored because of a lower morale and poor productivity that has affected their deterring investors. It is rising inequality, social resentment, and instability. Weaker consumer demand which can stall economic momentum. And why balance matters between the labor and the economy? It needs a rapid industrial economy growth to create jobs and reduce poverty. On the other hand, must ensure that growth does not come at the cost of workers' dignity and rights. The goal of balancing labor justice and economic growth means crafting policies that encourage entrepreneurship and investment, but also protect the rights and well-being of workers. The balanced approach ensures that economic growth is not only fast, but also fair, inclusive, and sustainable. And if that is being possible, and if we are able to achieve this target, which to my understanding appears to be very difficult as well, it will increase and help in ease of doing business, which the government always say from all platforms. It will enhance social security. It will improve workplace standards. It will put labor market formalization. But still people criticize the code of this labor code, that there is a delusion of rights. The job security is also taken away. The bargaining power of the labor is also reduced. Unless, I said, in large informal sector this is happening, but something has to be done. The government has to come forward in providing protection of rights of the informal sector, which is not organized and available within the law framework. Now comes what is the role of the judiciary in strengthening the labor laws and the economic growth of the country. Undoubtedly, the judiciary has to play a proactive role in expanding labor rights, not only by interpreting constitution provisions, but the international labor standards as well. Expanding the rights to life, promoting social justice, and expanding the social scope of protections. Judicial interpretations have consistently broadened the scope of who qualifies as a workman, industry extending legal protections of a wider range of workers. The landmark judgment of workers defined under the ID Act is way back in the 1979. I think this is a Bangalore water supply judgment that gives a horizon in expanding the scope of worker under the labor laws. And if we talk about the future of work and the labor justice in India, we have to protect automation and skill development. We have to address gender disparities. We have to strengthen social security. We have to secure the role of data and technology of the unorganized workers. And if we conclude and find out what can be the way forward, what comes to my mind, and I'll shorten to it because my brother just Lalit is also had to say a few words on the subject. We have to be very effective implementation of labor codes. How it is possible, it has to only find out by the stakeholders. We have to strengthen the social safety net. And if that is being possible, we have to investing in skills, government, industry, and education institutions. They must collaborate to create targeted skilling programs that align with the demands of the future economy, driven by AI and technology. There should be inclusive growth. It must be transparent and adaptive governance. To my understanding, this adaptive governance is the key of the whole system, which is missing today. And that is required for making the labor laws more effective, more workable, more adaptable to the people. That is what is required for the better cause, and if that is being followed, I find that we are able to do justice with not only labor, but all sectors who are serving the society as a whole. And only by this mechanism, what I feel, the balancing rights and economic growth of the country can be saved, can be protected, can be strengthened, and which can certainly serve the ease to do business in our country. I'm very thankful to give me this opportunity in addressing my views on the subject, and I don't want to detain my brother anymore to come and say what his expression comes forward to us. And thank you very much in giving me this opportunity once again. I thank the SRM Institute. I thank their stakeholder, the NDTV, in creating this platform and give us an opportunity to give us a vision as to how we can take the system more forward, more active, more acceptable, to develop not only the law, but all other stakeholders to join hands together with us. Thank you very much once again. Namaskar and Jai Hind.
Thank you so much for that. I request Dr. P. Satyanarayanan to felicitate Honorable Justice Retired Ajay Rastogi, former Judge of the Supreme Court of India. It was wonderful, sir, to hear your views on labor justice. Very sobering perspective, though.
Thank you, Anasuya. Known for his emphasis on gender justice, fair trial rights, and speedy justice, he initiated important institutional reforms during his tenure as Chief Justice of India. Today, we will hear from him on lessons from the Supreme Court, the role of the judiciary in strengthening democracy, and the challenges of justice delivery in India. Sir, I'll begin by delving into some of the very important judgments that you were part of. And the first thing that comes to my mind would be the instant triple talaq, and you were part of the bench that struck down the instant triple talaq. A milestone, of course, for gender justice, but with ongoing debates on uniform civil code and women's equal rights in personal laws, how do you see judiciary balancing faith and fundamental rights in this country today?
That's a very interesting question. First of all, I must congratulate all the organizers for organizing this symposium, which touches upon various issues of law, various dimensions of law. Right. Now, coming back to the question. See, one of the questions which was agitated in triple talaq matter was, look at the iniquity or inequality. Mm-hmm. A Mohammedan male can put an end to the marriage by triple declaration, but there is no similar right which vests in a Mohammedan female. So she can't put an end to the marriage on similar lines. Now, when this argument was advanced before us, I had put that question to the learned counsel, and I said, supposing if we accept your submission and hold that there is a unequal treatment, and therefore, just as a Mohammedan female cannot put an end to the marriage by triple declaration, if we hold that a Mohammedan male cannot put an end to the marriage by triple declaration, where do we land ourselves in?
Right.
Because then the situation would be that there is nothing in Mohammedan law which would permit a Mohammedan male to put an end to the marriage.
Yeah.
The only thing is what? Triple declaration. So therefore we had to moderate it and by judicial holding say that triple declaration, which is not in front of what is called Qazi or the elders of the family, is not a good law. So it is not as if that the Mohammedan male cannot still, even today, put an end to the marriage. Now that's the moderation which the court had to employ.
Right.
Why? Because otherwise you would be throwing the baby along with the bathwater.
Yes.
So therefore, you have to be moderate. Now when it comes to Uniform Civil Code, of course it is part of your directive principles of state policy, so therefore part 4 of the Constitution, but these are principles of governance. So as a principle of governance, perhaps I think the court would be slow to say that the legislature and the executive must start implementing it. It is not as if the court hasn't done that. Especially in, say, Unnikrishnan matter. In 1993, there was no fundamental right which was akin to 21 capital A. So what was, by interpretative process, what was held was that your right to life would be meaningless unless and until the entire bunch of, citizens, all the citizens put together are given adequate education. And therefore, primary education in the age group of 6 to 14 must be free and compulsory so that your entire population will hereafter be educated and that will enable them to attain their highest potential in life, just as Maneka Gandhi had specified. And they also relied upon one of the directive principles saying that it shall be the endeavor of the state to educate every child. Now they took that bold step in Unnikrishnan to say that yes, every child must be educated, but at the same time it will be very, very difficult to take that kind of bold step and say that Uniform Civil Code must be implemented all through the state. Because these are policy matters. And policy matters are normally not the matters or the sphere where the court would start ruling on. As and when the states have implemented, like Uttarakhand has actually come out with Uniform Civil Code, as and when some attempts are made in this direction, perhaps I think the correctness or the validity of that,
is always
as and when
challenged.
questioned, perhaps it will be done by the Supreme Court. But it has to have a different approach when it comes to subjects like this.
Right. It's not just moderation which it is looking at, but perhaps keeping up with the spirit.
Perhaps at the very basic idea, whether are we ready for that kind of uniform civil code, because this is something which is a policy issue.
Right.
The policy issue cannot be taken up by the court on its own, though I have given you an example where it was done,
Yes.
correct? But that is something where it was traced to your right to life under Article 21.
Yes.
And so therefore it became easier for the court to do that in Unni Krishnan. But perhaps I think it may be slightly, the issue stands on a different footing. Yeah.
If you allow me, but to just delve a little deeper into it, we were hearing Justice Deepak Gupta talk about the preamble and also negotiate questions with us on issues of the understanding of secularism. Where do you think Uniform Civil Code features if we are to first take a look at the preamble to the Constitution and also secularism as defined by the Constitution?
See, look at now some of the countries, Western countries. They are also secular.
Yes.
So United States or UK, everybody is secular there. In a sense, the government, when you say secular, what it means is that the government doesn't practice any religion.
Right. Yes.
Correct? So the government is apolitical and, does not actually subscribe to any religion as a primary religion. There are countries which are Islamic countries where they actually adopt that Islamic tenets to be the principal part of their governing structure or the apparatus. But there are countries which do not accept that, and yet those countries have uniform civil code.
Yes.
So therefore it is not an anathema. Right. Both things can sail together. The only thing is that you have to have that policy decision, and perhaps I think it is our lawmakers who must take that step in that direction. It is not as if that if you are secular, there cannot be uniform civil code.
Right.
So therefore these are two different things.
Right.
Please don't mix them up. Yes.
Thank you. I'll move to another landmark judgment in your career, which is privacy and data protection. The right to privacy judgment, you were part of that, and it laid the foundation for India's digital rights. With the new DPDP Act and the growing concerns over surveillance, do you feel the spirit of that judgment is being upheld?
See, these are again different issues.
Right.
When you put it at the level of privacy, privacy of an individual, which is essentially Part 3 right, correct?
Right.
Now, perhaps when you are thinking in terms of organizational structures or institutional level, perhaps I think different ideas may emerge. And that is something which it's a churning process which the lawmakers on one side, legislature, and the judicature, they have to now come out with and good ideas which will emerge out of that. So therefore, on one hand, you have what is called citizens' rights.
Right.
On the other hand, of course, privacy as a part, it arose in that Aadhaar and other cases.
Yes.
So therefore, like Puttaswamy and down the line. But then that was the fundamental part, was that whether, these kind of, you can compel somebody to give his body kind of, biometrics and everything. But that stands on a completely different level. But data protection is something which you yourself have uploaded on the virtual medium. Whether that kind of data needs protection or not, these are typically what is called property rights.
Right.
So property rights and fundamental rights, they have slightly distinct ideas. So therefore, perhaps I think that's a matter which needs to be resolved by the judicature and the legislature.
Right. Whatever I ask you, you're definitely going to be absolutely abreast of any controversial statements. You're going to stay away from it, I understand. So with that, I'll come to, during your tenure as CJI, you pushed for more constitutional benches, quicker listening of cases, it's a matter that we've been talking about since morning at this conclave. Given the persistent backlog and recent calls for judicial reforms, what systemic changes do you think are actually urgently needed?
Which are needed now?
Yes, to clear the backlogs, to address issues of backlog and the problems we face.
See, it's a mammoth task.
Right.
There are multiple or multi-pronged attack which is needed. Number one, first of all, when you come out with a legislation, which is a new legislation, there has to be proper impact assessment done by the legislature. Imagine a situation when 138 as a provision was introduced in Negotiable Instruments Act. There was not much impact assessment. As a result of which now today almost 40% of litigation on the criminal side in lower courts is nothing but your check bouncing cases.
Right.
Which is essentially a civil dispute getting color of what is called criminal dispute. So therefore, moment we embark on an idea such as that, you have to have greater legislative impact assessment. That is number one. Number two, you have to have a clear litigation policy coming from states. So every state must have a good litigation policy. Number three, when it comes to criminal laws especially, see, if you statistically look at, our conviction rate is never more than 20%.
Right.
Which means your 80% of your prison population who are under trials
Yes.
are bound to get acquitted someday or the late.
Yeah.
But you are still holding them in prisons. So what kind of legislative policy do you have on that? Or what kind of litigation policy do you have? So therefore, somebody must actually see to it that we must, first of all, connect ourselves to the merits of the matter and then challenge if there is a bail application.
Yeah.
So therefore, primacy must be given to your what is the merit situation. If unless and until you are dead sure that the man is bound to get convicted, please don't play with the individual liberty of that citizen. So therefore, that's also something, if you do that, number of matters which are pending by way of bail applications at every juncture will get weeded out.
Right.
So that's the third area. The fourth area, especially when it comes to Superior Court, I have certain other ideas when it comes to Supreme Court. For instance, it's the last court in the ladder. 136 today is being used as a regular appellate forum.
Yeah.
That's not the idea. It was always a discretionary idea. So therefore, perhaps, giving hearing to every 136 petition in court, we should have a different dimension to our listing patterns. No Supreme Court in the world, like say US Supreme Court, Canadian Supreme Court, take any Supreme Court.
Right.
It doesn't entertain every single matter in court, but we do.
Yes.
So therefore, what we can do is we can have benches of 3, put the matters before them as a screening idea. If even one person out of 3 says, yes, the matter requires to be heard in court, list it before the regular benches, but not before any 3 of them, any one of them, before completely different bench. But if 3 of them say in chambers that this is not worthy of, being agitated in Supreme Court, the matter must die there and then without getting listed in court.
Right.
So therefore, you will start weeding out, number of matters. You'll start controlling your arrears to a great extent. Then the fourth part. See, in good old days, Privy Council never used to grant interim relief.
Of course.
Half the litigation in superior courts is nothing but interim relief oriented litigation. So all that you, as a lawyer in my young days, I used to hear my clients saying, "Sir, kuch bhi karo, 5 saal nikal do court mein."
Right.
So therefore, this is nothing but an interim relief oriented litigation. The man knows that he has no case.
Yeah.
But he still wants to agitate. Why? Because he knows that if my case remains pending for 5 years, if I am a tenant, I'll be able to stick to my premises. If I am somebody who is out of jail, I'll still be able to remain out of jail.
Absolutely.
So therefore, try to weed out, and it requires a tremendous amount of efforts on part of everybody. The legislature, the executive, because then you have to be very, very clear as to which matters you are charging people with. So therefore, unless and until you are dead sure, please don't charge people, with offenses, and that will create, tremendous amount of solace to the entire prison population.
Since you mentioned your younger days as lawyers, I can't let you go without asking you a question about one of the most high-profile cases in which you represented the government of India, which is the 2G case. It was a case which had the biggest businessmen of the country, the biggest politicians of the country, all facing charges of corruption. In such difficult case, and you have fought many such other cases, what are the challenges you face to maintain impartiality? What are the challenges that you faced while ensuring consistency and also timeliness of the judgments?
See, my position was very, very, peculiar. I was not a regular public prosecutor coming from the stream of, a prosecutor's office. So in that case, there was no control over me by the government. I was appointed by the Supreme Court to conduct the prosecution. So therefore, I had a role which was cut out, which was completely impartial. So on one side, I was not bound to go by what the investigators had said. I was not bound to sort of toe the line or bound to sort of sing the same tune. Right. But at the same time, so far as accused are concerned, who were definitely on the wrong side, I had to carry the burden and say that very well they need to be punished. So they need to be sort of proceeded against law. So I maintained a very impartial posture all through. Like for instance, after Sanjay Chandra came as a decision, which said that the moment you complete 6 months in a case where the sentence is not more than 7 years, then the person concerned must be released on bail. So therefore, I never contested matters on that count. So therefore, everybody got released after completing 6 months. So on one side, I was impartial so far as accused are concerned. On the other side, I was also equally sort of forceful when it came to charging them under various sections. So it was a very difficult role which I had to play. There was no instruction which was coming from anybody. So unlike the normal lawyer who actually acts on instructions, I had to act purely on my understanding of everything, my own conscience, and so therefore it was a burden which was there. But I am happy that I could discharge that very, very dutifully and quite well.
Of course. My last question to you, and I can't let you go without this question. There are so many students in audience. If you could reimagine the legal education system in India to prepare future lawyers who would then perhaps some of them go on to become judges, what would be your top 3 priorities?
Priority number 1. See, unlike medical schools, where there is an internship, so internship would mean that you have to actually serve the society for 1 year. I don't know why they haven't introduced that kind of internship when it comes to law as a course or engineering as a course. Is it only that medical students alone are supposed to serve the society? Why not law students? So therefore, as a person who was in charge of NALSA, I had introduced an idea which is like public prosecutor, there has to be an office of public defender. Public defender's office will defend all the accused who require legal aid as an office under the protection of the state. Their salaries, apparatus, the facilities, everything would be borne by the state. So therefore the state would be in charge of that particular scenario, the regime. Now, in order to man those kind of, ideas, just as you require medical students to man your primary healthcare centers, why not have fresh law graduates who are coming out of law schools spend at least 1 year in the office of public defender? So thereby what happens is that they will be, what a thought will get inculcated, that you are here not just to sort of, pursue your career, but pursue your career with an additional kind of, framework that you are serving the society. So therefore, as a legal education, perhaps I think that part is something which must get added. Then the second part, I would submit and I agree with Justice Rastogi when he said that this 3-year kind of situation to join judiciary
Yeah.
may not be necessary. You can reduce it to 1 year, and those who have done public defender's office 1 year, they should be straight away considered to be taken for the judiciary kind of, postings. So therefore, that way you will create an awareness amongst the students that if I do this internship, there's an horizon which is waiting for me in the form of, say, judicial service as such. So therefore, there are a number of ideas which can be implemented like this, which will make your legal education very, very substantive and very sharp and focused one.
Thank you so much, Your Honor. It was a pleasure speaking to you, and thank you for taking the time out, coming all the way to Chennai to be with us. Thank you once again.
Thank you so much. I enjoyed this. Thank you.
Thank you for that wide-ranging conversation, sir. Do stay with us on stage. I'd like to invite once again Dr. P. Satyanarayanan, Pro-Chancellor Academics, to felicitate the Honorable former Chief Justice of India, U. Lalit.
Good evening, ladies and gentlemen. Morning, we have started our day with a brilliant speech by Honorable Justice N.V. Ramana. He has taken us 70 years before how the legal practice will be. First of all, on behalf of SRM School of Law, SRM University, it is my privilege to propose a formal vote of thanks at the conclusion of remarkable symposium, Lexposium 2025. First and foremost, we are deeply grateful to our founder chancellor, Dr. T.R. Parvinder sir, and Pro-Chancellor Academics, Dr. P. Satyanarayanan sir. Thank you so much for providing this wonderful opportunity. And after that, we are very much thankful to our Pro-Vice Chancellor, Professor A. Vinay Kumar, Registrar Dr. S. Ponnuswamy, and Pro-Vice Chancellor Medical Dr. Nitin Nagarikar sir for their leadership and guidance for a fruitful accomplishment of this symposium in a successful way. And I owe my heartfelt gratitude to our distinguished keynote speakers, Honorable Chief Justice, retired N.V. Ramana, Supreme Court of India, Dr. Abhishek Manu Singhvi, Member of Parliament and Senior Advocate, Honorable Chief Justice, retired Geeta Mittal, Chief Justice of Jammu and Kashmir High Court, Honorable Justice Sanjay Karol, Supreme Court of India, and Honorable Justice, retired Ajay Rastogi, Supreme Court of India, and Honorable Justice Dr. Anita Sumant from Madras High Court, and Honorable Justice Deepak Gupta, former CJI, High Court of Tripura and High Court of Chhattisgarh, Honorable Chakradhari Sharan Singh, former CJI of High Court of Orissa, for their message for the purpose of preparing future advocates. Respected sirs, your words have highly enlightened us on judicial reforms, constitutional morality, access to justice, as well as uniform civil code. These fields are one of the most important fields for the purpose of shaping the future advocates, which are very much responsible for fostering socio-economic growth. And after this, I extend my sincere thanks to our Additional Registrar, Madam, Dr. Maithili, Madam, for her support as well as best wishes for successful conduct of this program. And I also extend my sincere thanks to our panelists, Mr. Nalin Kohli, Dr. Pinky Anand, Mr. Pradeep Rai, Ms. Swapna Sundar, Mr. Jan Sharan, Mr. Arun Balaji, and other panel members for their thought-provoking insights on the topic of law and ethics for Vikasit Bharat, as well as AI, cybersecurity, and the future of legal careers. Thank you so much for your thought-provoking panel discussion. And we are also privileged to have an enriching fireside chat with Honorable Chief Justice, retired UU Lalit, Supreme Court of India, as well as Shri Satyapal Jain, Additional Solicitor General of India, and Mr. Cyril Sharaf, Managing Partner, Cyril Amarchand Mangaldas, for their valuable insights. After this, I also thank Dean Shivabhargava sir, as well as Albert sir and Doreswamy sir for their sincere support. I thank all of you for supporting us for successful conduct of this program. And after this, a special word of thanks for our moderators, T.M. Veeraraghav, Vasudha, Venugopal, and Ms. Suchetana Roy, and Ms. Anasuya from NDTV team for their support throughout the sessions. And I also extend my gratitude for our print partner, The Hindu, our digital partner, The Federal, and our broadcasting partner, NDTV, for their collaboration and support in making this event a grand success. Not last but not the least, I thank Mr. Dev, Director, Communications, Ms. Divya, Assistant Director from the Department of Communication, and their team for their tireless working throughout the program. Thank you so much for your warm support. And a special thanks goes to Dr. Shantanu Patil of SEI for their sustainable coasters and layouts curated in-house from our own Fab Lab. Thank you so much. I also extend my heartfelt thanks to our campus director, Dr. Thirumurugan, and Mr. P. Samir, Associate Director, ITKM Department, for their tireless effort for providing technical support for this event. So I also extend my heartfelt thanks to Director Transport, as well as Director SRM Hotels, AHA team, for their warm support. And I also thank teaching and non-teaching staff from School of Law for their support. And finally, our deepest gratitude goes to the organizing committee, faculty members, staff, and the students of SRM School of Law who have worked tirelessly behind the scenes to make this symposium a grand success. Finally, to all our distinguished guests, delegates, participants, thank you for your presence and engagement. Your support makes our journey towards academic excellence and preparing the future advocates for building this nation as Vikasit Bharat. With this, I conclude the vote of thanks. Thank you so much. We look forward to meeting you all again in our future academic journey. Thank you, one and all. Thank you so much.
Thank you so much, ma'am. There are just 2 or 3 more partners who we do need to acknowledge for their support in making this possible. SRM School of Law presents Lexposium 2025 in association with NDTV, healthcare partner SRM Global Hospital, media partner The Federal, print partner The Hindu. And now, to close the event, I would like to invite on stage a student of SRM University, Farhad Hussain, along with his guitar. Ladies and gentlemen, please rise for the national anthem of India.